much equipment here, it's hard to find everything. Okay. Good morning and welcome back. We got 10 people here in person, and it's been a long time since we've been together and since we've seen faces out in the audience making in-person deputations. So in accordance with sections 45 and 53 of the Planning Act 1990 as amended, this meeting of the Committee of Adjustment of the City of Toronto is called to order. The Committee of Adjustment considers applications for variances from the provisions of the zoning that apply to the property, permissions to extend or alter lawfully non-conforming uses, and consents to sever properties to create new lots. Land acknowledgement. We acknowledge that the land we're meeting on is traditional territory of many nations, including the Mississaugas of the Credit, the Anishinaabe, the Chippewa, the Haudenosaunee, and the Wendat peoples, and is now home to many diverse First Nations, Inuit, and Métis peoples. We also acknowledge that Toronto is covered by Treaty 13 with the Mississaugas of the Credit, and the Williams Treaty signed both multiple Mississaugas and Chippewa bands. Committee of Adjustment public hearings are now conducted in a hybrid in-person and virtual format. Some applicants and participants will make their submissions in person, and others will participate virtually by electronic means through WebEx, an online digital platform. The meetings are also streamed on the Toronto City Planning YouTube channel, and anyone wishing to view the hearing may watch on YouTube. Those who want to participate virtually and have registered in advance will be connecting with their computer, tablet, smartphone, or telephone and have the option of participating via video or audio only. All virtual participants will automatically be muted on entry, and when your item is called, you will be unmuted by the moderator, one person at a time, and we also ask that you mute your devices until you are called on to speak. Those participating by video appearance will be temporarily upgraded to panelist when your item is being held. During this time, your camera will be enabled, and you will be visible during your 5-minute allotted speaking time. At all other times, your video will be disabled and you will be reinstated as an attendee. For both in-person and virtual participants, Committee of Adjustment staff will share presentations submitted in accordance with the written submission deadline. Those participating through WebEx are not allowed to use share screen or any other panelist controls during a video appearance, and the host will remove you if you fail to respect this instruction. Receiving a copy of the decision of the committee. People attending in person today who want to receive a copy of the decision of the committee on an application must fill out a decision request card, and those participating virtually need to submit a written request for a decision by email. Please ensure that you include your name, address, and email address, because the Committee of Adjustment and the Toronto Local Appeal Body, in the event of an appeal, will be sending notifications and appeal updates by email. If you do not agree with the decision of the committee rendered here today, you may be able to appeal the decision to the Toronto Local Appeal Body or, in some limited circumstances, to the Ontario Land Tribunal. However, the provincial government amended the Planning Act and generally removed rights of third parties to appeal Committee of Adjustment decisions. Only the applicant, the Minister of Municipal Affairs and Housing, specified persons and public bodies, as those terms are defined in the Planning Act, are permitted to appeal decisions of the Committee of Adjustment. Appeal instructions are set out at the bottom of the decision of the committee. The hearing procedure in the hybrid format will go in order after first dealing with deferrals, and there are a number, I believe 5 deferrals that we're going to be dealing with at the outset, and then we'll go on and start going back in order, starting at item number 1. In making submissions where an application is uncontested, where it means that there's no one here to make deputations against the application, but there may be certainly letters or city departments concerned, but where there's no one here to speak other than the applicant or their agent, they may proceed with a presentation if they desire. Where the committee does not require presentation, applicants are to advise the chair in advance should they wish to address the committee. And the committee may ask questions of the applicant and then take the matter to the committee for a decision. Each speaker, including the applicant or their agent, will be given a maximum of 5 minutes to address the committee, and the clock is up on the board and will comment when you're reaching or have exceeded the 5-minute mark and ask you to wrap up. Any presentations or other materials you wish to submit to the committee must have been emailed in advance of the hearing. Staff and committee members cannot accept materials at the hearing. When addressing the committee, please start out by clearly stating your name and address for the record, and please remember to confine your remarks to the matters outlined in the application. The applicant or agent goes first and makes their presentation to the committee on a contested application. Please note the committee may not entertain revisions to proposals made at the hearing today. The committee may decide to defer the hearing if being substantially revised in order to ensure that the application is accurate and that all those entitled to notice of the application have been informed of the changes. Then individuals either in support or opposed to the application will be invited to speak. Generally, we first call on speakers in the hearing room and then those participating through WebEx. Committee members may ask questions of each speaker after they finish their presentations, and when all speakers have finished, the applicant or their agent has an opportunity to rebut only those issues and answer those questions that were raised by the speakers. That will then mark the end of the discussion, and the application is then taken into the committee for a decision. We have some housekeeping matters to take care of to confirm the minutes of the last meeting. I believe it was July the 8th. Okay, can I have a motion to approve those minutes?
I'll move for approval.
Thank you, Mr. Palmer. Seconder for that.
I'll second, Mr. Chair.
Thank you, Mr. Taylor. All in favor? The minutes are approved. Do any of the staff or panel here have any declarations of interest to declare on the items before us in this morning's agenda? None to declare. Okay, thank you. Okay, so deferrals. We had a consolidated memo from staff. There were two on the consolidated memo that we get from the planning department, and then in going through the agenda, we found there were several others. So we will be dealing in this, and we'll go in order on the deferrals first. So we'll start with items 4, then item 5, then item 7, 13, and 14. So I guess the first item is item number 4, 83 Albert Avenue. And we only have the one speaker, Alan Diaz, the agent for the applicant, who says did not register. I don't know if he's here in person or, so when we do that, are we going to know, I guess does it show on the attendance sheet if they're here in person, or yes, it does. Okay. So.
It will, just with each item, you will have to ask if anyone's here in person.
Okay.
In the event that they show up.
We have to ask if there's other neighbors in person who may have come into the room who didn't register.
Yes.
So, okay. So we have Alan Diaz.
Can I ask everyone to turn off their cell phones or silence them, because that's very disruptive?
Okay, so 83 Albert is an application to construct a third floor addition in order to accommodate 2 additional dwelling units. It will create a total of 8 dwelling units within the existing dwelling. And on this application, we have planning is recommending deferral or conditions of approval. We have the revised housing, a rental housing form that's been completed. And we have a memo from the rental housing department dated July the 6th, and they, it looks like they need more time, so it looks like this request for a deferral is in order to accommodate that.
Chair, can I also add something? Transportation appears to have been provided an updated site plan dated July 7th that we weren't provided. And I don't know if other departments were provided.
Okay, I see they have they're also, transportation has conditions of approval, but if this matter is going to be deferred, it's something that they can deal with, I guess, in the deferral period if we're not proceeding today. So do we have the agent Alan Diaz on the line? And is there anyone else here in the room dealing with 83 Albert Avenue? Are there any neighbors or concerned parties? Okay, none. So we all just have Mr. Diaz on the issue of the deferral. And there were 5 variances on this application.
Mr. Chair and members, Alan Diaz is present on the call. Alan, you're unmuted, so go ahead. Mr. Chair, as a note, we weren't able to do a microphone check with today's new processes, and we weren't able to confirm whether or not the folks were properly set up on the remote side.
I don't know if it's possible, sometimes with a deferral, they may not realize they have to attend. I don't know if that's, is there any staff person who's dealing with Mr. Diaz on this?
I can't speak to that, Mr. Chair, but I can confirm Alan Diaz is present on the call at this
Oh,
time.
he is, okay.
Yes. Alan, you're unmuted. Go ahead. Mr. Chair, maybe we stand this one down.
Okay.
Alan, if you could log out, log back in, make sure you authorize the use of your microphone. We'll make sure we get a chance for you to speak to the deferral request. Thank you.
Okay, and then item number 5, which is the next application on the deferral list. It's 69 9th Street, or is there anyone in the room present on 69 9th Street to make comments? The agent is Dragan Asimovic, and it looks like he also has not pre-registered.
Mr. Chair, the agent is not present on the call at this time. Mr. Chair, I'll go ahead and unmute the user Dan Asimovic, and we'll see if this is who wants to speak.
Okay.
Dan, go ahead.
Good morning. Hello.
Hello, your volume is pretty high. This is for an ancillary structure in the rear yard and to contain a detached garage and a rental suite. And I believe we had in the additional materials an email about there's some variances missing.
Correct. We did receive an email from the planning department
Actually,
a couple of
start
days.
off by stating your name and address for the record?
Certainly. My name is Dan Achimovic. I'm calling from DA Design. We're located 1185 Queensway Queensway East in Mississauga, and I'm the agent for this file.
Okay, so it appears you need a variant. You need a deferral due to a variance. It looks like there's been a date agreed upon to have this matter brought
Correct.
back on.
Correct. August 17th.
Okay, so can you just state the reason is because you realized after a zoning review that there were some variances missing that hadn't been on the notice?
Yeah, I mean, apparently the notice that was issued missed one of the variances, and I think that's an automatic deferral because of that,
Okay.
as per the planning department.
Okay, thank you. Any questions for the agent, Mr. Asimovic? And if not, is someone ready for a motion to defer this matter to the specified date?
Mr. Chair, if we could just do to the next available hearing date, we're just waiting for a revised zoning review. So if we don't get it in time, we have to mail by tomorrow. If we get it in time, then yes, we will put it on for August 17th.
Okay, so it makes sense to, I guess, to do that because to make sure that they can meet the deadline for the notice for the next for that meeting. So can I have a motion?
Yeah, I'm happy to make that
Unless anyone
motion.
has any questions.
If no one has any questions, I'm happy to make that motion. I move for deferral because of the error in the notice to the next available date.
Okay. Seconded for that motion.
Second the motion.
Thank you, Mr. Kamarick. All in favor? Okay, the matter is deferred. We'll see you back here again, Dan, when you have the application ready. Okay. Okay, the next is a matter that was on our deferral memo for reason number 6, being a request by the applicant. Item number 7, 158th Street. This is for a 6-story residential apartment building. And in an email, we have a deferral request on July the 10th from the agent. The speaker on this application is Adam Layton. He is going to be on video. It says virtual audio, so I guess that means he's not going to be on screen. And is there anyone here on 158th Street in the room? Okay, no. So let's hear from Adam Layton.
Mr. Chair and members, Adam Layton will not be speaking on this file. The speaker is Devanshi Mehta. Their request for deferral was on the board a moment ago. I'll go ahead and unmute them now.
Good morning.
Good morning. My name is Devanshi Mehta. I'm the agent from Evans Planning. Address is 9212 Young Street, Unit 1, Richmond Hill, Ontario. And I'm here to request a deferral as we are working with the staff to correct the zoning notices.
Okay. Okay, so the members, any questions for Ms. Mehta? And if not, is someone ready for a motion?
I'll move a motion to defer so that the applicant can correct the notice.
Okay. Seconder for that motion, Mr. Kamarick.
Happy to second that motion.
Okay, thank you. All in favor? Okay, the matter is deferred. We'll see you back here again.
Thank you.
Okay. The next item on our deferral list is item number 13. That was also on the consolidated memo for reasons 1 and 2. Looks like staff needs more time to review the application. Again, it's Dan Asimovic.
Good morning again.
And again, just let's check, is there anyone in the room dealing with item number 13, which is 47 LAPP Street? Okay. So this is was for a new laneway suite in the rear yard, and there were 3 variances, and staff is looking for a deferral. The speaker on this application, oh yeah, it's Dan. Dan, are you agreeable to staff's request? The last one was at your request. This one is for items 1 and 2 on the planning memo. So are you agreeable to having this matter deferred as requested?
Correct.
Community.
Yes, sir. We are, yes.
Okay. I take it, with these laneway suites, they're a little more, complicated. I assume staff needs more time to review it with you.
Correct. Very challenging little projects.
Okay, thank you. So, members, any questions for Mr. Asimovic, or is someone ready for a motion?
If no one has any questions, I'm ready for a motion. Because community planning would like it deferred, and the applicant has also asked for a deferral and agrees with community planning, I move for a deferral.
Seconded for Ms. Alderson's motion. Mr. Palmer, thank you. All in favor? Okay, the application is deferred. We'll see you here again. You can now take the day off, Mr. Asimovic. Okay, our last deferral matter is item number 14. 65 CLAYBROOKE Street. This is a 1-story addition above the existing building and a new ancillary building with 8 variances. We had nothing on file in the additional material. We had the request from the agent. They got a new zoning notice and realized there's a missing variance. So the speaker, Marco Vieira. There was another speaker, but looks like they're no longer.
Members of the committee,
Yes.
Marco Vieira here as the agent, and we're asking for a deferral because variance number 5 has an error on the proposed percentage of landscaping. It's actually 1% lower. We thought of complying that, but the examiner did review and revise the notice and added a subsection to that variance. So as a result, I believe new variances have to be sent out, and we asked to be placed on the next available hearing.
Okay, well, I guess once that's been done, I guess you'll contact staff. We'll put you on the next available hearing. I guess the next hearing is, I believe, the agenda is going out, or the notices go out tomorrow. So it may be the meeting after that, next after you're done what has to be done and the matter is corrected. Anyone have any questions for Mr. Vieira? And if not, is someone ready for a motion?
I'll scratch in my head, but I'll do a motion to defer.
Okay. Mr. Kamarick, a seconder for that. Mr. Taylor, thank you. All in favor? Okay, matter is deferred. Mr. Vieira, we'll see you back here later in the day. I see you're on item 15, but we're going back, a good segue. We're going back to item 1 now that we finished the deferral.
Mr. Chair, as a reminder, There was that deferral we didn't get
Deferral
to.
Item 4, right.
And I can confirm Alan has logged out and logged back in, so hopefully this time his microphone will work.
Okay, perfect. Okay, Mr. Diaz, 83 Albert Avenue.
Go ahead, Alan.
This is for 2 additional dwelling units for a total of 8 within the existing dwelling, and we have a planning request to defer or conditions of approval. We have the rental housing form filled out and the rental housing memo. And transportation is okay, but conditions of approval. But Mr. Palmer, if you can also address that, he advises there's a revised site plan that we haven't seen.
Hello.
Mr. Diaz?
Yes, I'm here.
Okay.
Can you hear me?
Yes, we can, loud and clear. I can just state your name and address for the record and then speak to the matter of the
Okay.
deferral.
Okay. Alan Diaz, 2326 Bloor Avenue in Markham. I'm the agent for this application. Okay, so we throughout the course for the past week or so, I had been coordinating with transportation and also planning with regards to the information that they required. As far as transportation is concerned, the 2 variances related to parking have been cleared. So that's something that we would have to remove from the relief request. And the items that planning needed, I was able to just send the letter signed by the landlord yesterday. So if they need more time to review it and along with yourself, then I would agree to the deferral to the next available hearing.
Okay, thank you. Members, any questions for Mr. Diaz? And if not, is someone ready for a motion?
Sorry, Mr. Chair, could I just ask a question?
Of course.
Sir, I'm assuming you have a problem with moving forward with this application with the condition requested by community planning? Am I right?
I do not have a problem. We've tried to address it and I have given the material, but they haven't had a chance to review it and give you updates.
Well, I don't read their condition as requiring their pre-approval. They're just asking for if the proposed work results in changes to the number of units, the owner shall obtain approval of a rental housing demolition permit prior to demolish any existing rental dwelling unit at 83 Albert Avenue.
So
I'm just wondering.
Planning's recommendation is to defer. If you don't defer, they're recommending refusal. If you don't refuse, then they're recommending the condition. But ultimately, they want a deferral to get the information and process it from the applicant.
Okay, I'll move deferral then.
Okay, thank you, Mr. Taylor. Second for Mr. Taylor's motion.
I'll second that.
Thank you, Ms. Alderson. All in favor? The matter is deferred. We'll see you back here again, Mr. Diaz. Okay, that concludes the deferral. So now, and I didn't ask if there was anyone in the room, but I assume there wasn't anyone in the room dealing with that particular item. So we'll move back to the top of the agenda and start hearing applications. The first application, I guess, Madam Secretary Treasurer, we should be hearing 1 and 2 together.
That's correct.
They're for 23 green lanes and 25 green lanes. It's an application to maintain the existing detached dwelling with a detached garage. There are 2 variances. We have planning report for information. We have a cover letter from the solicitor for the applicant. We have engineering construction services, and we have forestry comments. And this is basically we were advised it's a technical consent to restore the lot frontages in area for 23 and 25, which under the Planning Act, the lots merge when they're owned by the same owner. So inadvertently, that's what happened here, and they just want to establish that there's no construction anticipated with this. So the speaker for this application is Velta Musalam for both applications. Welcome, and we have your cover letter.
Mr. Chair and
Good
members,
morning.
Veltum has asked to be on screen for their presentation, so I'm going to go ahead and make them a panelist now. So if you bear with me for one moment.
Okay, and perhaps if we can ask in the meantime, is there anyone in the room present on 25 or 23 Green Lanes? Yes, okay. So you're, oh, just to watch, you're not going to make, okay, thank you, sir.
Velta, go ahead and you can start your video by clicking the start video button. Oh, you have, thank you. Let me go ahead and drag you in and we can update. All right, Mr. Chair.
Yeah, we have your cover letter.
Velta, you're muted. You have to unmute yourself.
Right. Okay.
Okay, welcome.
Good morning, Mr. Chairman and members of committee. My name is Velta Salem, 16 Shieldmark Crescent, Thornhill, Ontario. I'm the applicant representing the owners of 23 and 25 Green Lanes, Ivana Horchiakova and Boris Horchiak. Mr. Horchiak is in the council chamber today to observe the proceedings. The two minor variances before you, as you said, Mr. Chairman, are related to the delegated item, which is the technical consent. Green Lanes is a street of post-war bungalows. The layout of the lots and dwellings is on a survey that I submitted with my application, which is dated November 18th, 1946. And the houses that are there today are the same bungalows that were built in the 40s. The Horchiaks purchased 25 Green Lanes in 2001. In 2013, they purchased number 23 Green Lanes along with Mr. Horchiak's father, Ivan. The father was removed from title in 2015, and as you said, Mr. Chairman, inadvertently the lots merged because the lawyer who's now deceased had not advised the Horchiaks that they needed to have a separate title. So the applications you have before you today are to reestablish the two separate lots as they originally have existed since the 1940s, and this requires variances for a minimum lot area and minimum lot frontage. So we respectfully request that the committee approve the required variances to the bylaw. We've reviewed the conditions from engineering and construction services and urban forestry and find them satisfactory. Thank you.
Okay, thank you. So I guess neither of them went to law school. You learn in first year that when you do that, the properties merge. So it's clearly just a Planning Act problem. So anyway, anyone have any questions for Velta Musalam?
Just a comment, Mr. Chair, for us.
Yeah.
The actual consent aspect of this proposal is a delegated file, so we're only dealing with the minor variances.
Okay, so there's also a companion application that goes to, I guess, the Secretary Treasurer, who deals with those applications. Okay.
So I'm prepared to make a motion with respect
Can I
to the.
just add something to that before you make your motion? It appears that the conditions from engineering and construction services are related to the consent.
Right,
So really the only condition is forestry, right?
exactly.
Okay.
So my motion would be in recognition of the fact that this is a technical severance due to an inadvertent merging of titles. The variances are what they are, and they happen to be, in my opinion, minor and in keeping with the 4 tests under the Planning Act. So I move approval of the 2 minor variance applications related to 23 and 25 Green Lanes, subject to urban forestry condition 3.
Okay, thank you, Mr. Taylor. A seconder for that?
I have urban forestry condition number 1 as well, so I don't know.
I just had 3.
I just have 3, and 3 is only for item 2,
Yeah.
Okay,
for 25 Green Lanes.
all right,
Sorry, the urban forestry condition was for another file.
okay,
Right.
okay. So I'll second that motion.
Okay. All in favor? Okay, so that's on both applications 1 and 2. The application is approved for both matters. Thank you. Okay, our next application is 38 33rd Street. This is, just go. Where's my mouse? It's an application to convert the basement into one additional dwelling unit. There's one variance, which is a setback. And that's and we don't have anything whatsoever on this file. The agent is Jonathan Benkowski, who I assume is appearing virtually. Is there anyone in the room here on 33rd Street? Yes? Thank you, ma'am. So you'd like to make, you're going to make submissions after the applicant has spoken. So I'll just let Mr. Benkowski know. Okay, Mr. Benkowski.
Yeah, so this is a proposal just for interior alterations. That is the existing side yard setback for the property. It really is just to put an additional dwelling unit in the basement. Again, there's no additional height. There's no reduction in side yard setback, front yard setback, or rear yard setback, or any additional length proposed. And I'm happy to hear what the neighbor has to say.
Okay, so is this just because, like, it's an existing situation, it wasn't otherwise dealt with or authorized by the committee in any other matter, so now it has to be dealt with? It comes up as the only variance, and like you said, this particular request, the purpose does not trigger that variance. So it's a very interesting thing. You have this whether
Mr. Chair, I totally agree with you. I went back and forth with the zoning examiner as well as the manager of buildings in that section, saying this is a lawfully existing setback. We actually should not require a variance for it.
Yeah. Or make an application and pay a fee, but anyway.
Correct. We went back and forth. They ultimately said, no, because you are making it an additional unit, the zoning bylaw specifies for a triplex a certain side yard setback. So again, I still do not believe we require this, as this is a lawfully existing setback.
Yeah.
Nonetheless, the management as well as the zoning examiner said we did. Additionally, they actually requested a lot frontage setback for a lawfully existing frontage of the property. I managed to have that removed, but I could not get the setback removed.
Okay. I'm as perplexed as you are, sir. Anyway, anyone have any questions for Mr. Benkowski? Or if not, we'll hear from the neighbors. We'll have one speaker, I guess, for each address. If you're more than one address, come up to the podium to make deputations, but we only have one speaker from each address, so I don't know who's intending to speak. Okay.
One quick question.
Yep.
What'll be the total number of units in the dwelling once the basement is converted?
3.
3. So there are two above grade units.
Correct.
Okay, thank you.
Okay.
That's my vote. I get it.
Yeah. Okay. Good morning, ma'am. We'd like you to start off by stating your name and address.
My name is Joanne McKinnon, 15 Marina Avenue. Speaking on behalf of my father, and apparently my neighbor who doesn't speak very well.
Okay,
she's a senior.
We need to know their names and address.
Her
or
name is Vivi Vatra.
Right.
And she's at 42 33rd Street,
So
right
is that
beside.
right next door?
Right
There's no
next door,
40, so
exactly.
it's right next
There's
door,
5
40.
existing properties surrounding that one property.
Okay.
All of our understanding is that's a single dwelling unit. When did it get changed to a multi-unit, which now apparently is going to have 3 units in it if you include this basement apartment? Plus, they've built a 2-story ensuite garden house in the backyard, which is now taking up everybody's view. It's staring right into my backyard, so there's no privacy whatsoever anymore. The average family is about 4 people. If you're putting 4 families on that property, you're looking at about 16 people on one small property. Where are they going to park? Where are they all going to play? As COVID has taught us, putting a lot of people in one small space doesn't work out very well. Everything, our sewage goes up, our garbage goes up. Parking, where are they going to park? You're looking at probably anywhere from 8 to 16 cars pending on the size of the families that are moving in. There seems to be a misconception that there's a housing problem. There is not a housing problem. There's housing everywhere. There is an affordable housing problem. And unfortunately, this, I do believe, has now been switched into a company name. So you have companies buying properties for profit. And in their profit, we as the neighbors are suffering because you're putting more apartments, splitting houses, adding more. And we pay for those rights. We want our neighborhoods. Long Branch has always been large, spacious, open. That's what people pay for. Now it's being taken away from them. But where do we stop with this? I'm not sure. They've bulldozed all the trees down. There was beautiful Rosa Sharon trees. There was beautiful bushes. Everything has been annihilated on that property. There is nothing, no greenery in that backyard at all. It has completely been annihilated. And nobody's doing anything, and I don't understand what is going on. Like, how did it get switched into a multi-unit house without anybody knowing about it? So it's 3 apartments in one house, plus another giant house in the backyard.
Is someone living in the house in the backyard?
No, it's still being built.
But it's,
And we didn't even know about that. We found out after the planning was done, and I don't understand. So where do we stop? We need this to stop, because it's not going to be affordable housing. With the amount of money that people are putting into these buildings, if they make it affordable housing, they're never going to get their money back in their lifetime. Not with the way things cost nowadays, unfortunately. So it's all about profit. They're going to be renting that out for top dollar. So you now have got 4 top dollar properties on one property. It needs to stop. We as neighbors, we like our peace and quiet. We pay for our peace and quiet. And I also want it to be known that the fencing that's going up, like, we're not vindictive people. We are one of the only 5 people that have offered to pay for our portion of the fence that's going up.
Okay, so you speak, you have another 45 seconds, and then Mr. Benkowski responds to what you have to say.
Mm-hmm.
We don't respond, he responds.
No, okay, understand.
So tell me when you're finished, and...
well, I'm pretty much finished, yeah.
Just before I go back to Mr. Benkowski, just want to explain to you what the Committee of Adjustment is about. We deal with variances of the zoning bylaw. This purpose of this application is to convert the basement into 1 additional dwelling unit for a total.
Oh, sorry, excuse me, my apologies, since I have a few more seconds. That basement floods. They have a sump pump, I do believe, and when he purchased that house, the sump pump failed and filled up 4 feet of water. If that happens again, somebody's going to drown down there. So that has to be looked at too. There is issues with flooding on that property.
So, as I was saying, the Committee of Adjustment deals with variances to the zoning bylaw. In this case, the only variances, I was puzzled at the outset of why Mr. Benkowski even has to be here, and he's responded, is that the only variance is an existing condition being the north side lot line. The distance from the house, the dwelling unit, which has been there for a long time, to the north side. Other than that, we wouldn't be here today dealing with this application. So it's, sometimes you see what someone's trying to do is not permitted under the zoning bylaw. It doesn't say that here. We're only dealing with one variance, was at the existing north side lot line. So all of the things which you may have said, may be valid or whatever, but it's not within our authority. Our authority is only to consider this one variance being the deficiency in the north side lot line.
So people can just put in...
They can do whatever is permitted under the zoning bylaw. And the only thing that they're doing that's not permitted under the zoning law that they're here to get permission for is the distance from the north side lot line. Not with the number of dwellings on the lot, not with the number of people on the lot, nothing to do with the trees or the fence.
So I'm sorry, I'm confused. So people can just put in as many apartments in their house as they want and nobody can do anything about it? I'm sorry, I'm confused on that
If
side
the
of it.
bylaw permits it. I'll let Mr. Benkowski respond. Okay?
Okay.
Thank you. So first of all, I want to see if any of the members have any questions for you.
I actually have a question. I wonder, in your opinion and in the neighbors' opinions, is this property well maintained, looked after?
I'm sorry, they've had ownership of it for a couple of years. My answer is no. They have not shoveled once since they purchased the property. They have not mowed their lawn. They just actually did it a week ago, and that's the first time since not last summer, the summer before. They've done no maintenance to the property. They just wiped out everything.
And has any of the neighbors ever called property standards to the best of your knowledge?
I do believe so, yes.
Okay.
I don't know which ones, but I do believe so, yes. Because I know they put a stop to taking 2 of the trees down. And then it continued.
Okay, thank you.
Thank you.
Okay, so let's hear from Mr. Benkowski in rebuttal.
One moment, Mr. Chair, while we get things kind of tuned up here. Okay, go ahead, Jonathan.
Thank you. So there is a building permit issued for the erection of the garden suite in the rear yard. It was issued in March of 2023 and is in the inspection stage right now. So that garden suite, again, was erected with no variances required. It was building permit issued, zoning bylaw compliant. Again, in terms of the number of units, the built form and the plan context of Toronto is going to change drastically based upon the recent changes permitting fourplexes really citywide. So in terms of that plan context of adding units, yes, that is permitted. Again, the only variance requested is for that existing side yard to convert this into a triplex. There is no alteration to the property itself. In terms of the upkeep of the property, this is a construction property right now. There is a garden suite being built in the rear, as well as interior alterations to the existing building itself. Proposals like this are going to become more and more common. And again, this follows the direction of the province, as well as the direction of the City of Toronto Planning Department. I'd be happy to answer any questions that you might have.
Okay. Any questions for Mr. Benkowski?
Sort of. So it's sort of the notice, when you read the notice, the essence of what I got from it is that you were adding a secondary suite, so it didn't say that. But what you're in fact doing is converting the home to a triplex. And I just wonder whether the notice should have been reflecting that as well, but that's my question.
What I could say to that, Mr. Kumrick, this was done before the permission to permit triplexes. So often what took place before was, even if you had a 2-family house and you put a basement apartment in, it would be to add an accessory unit. So it's not uncommon from what happened in the past. It is going to change that these now will be considered triplexes because you get certain relief from the zoning bylaw in terms of no requirement of FSI, additional heights and things like that.
No,
But
I understood.
going back to how this was originally done.
Well, I think some of the confusion comes in play because of the changeover, so understood. Thanks.
I know we have no communication from any city departments on this application, correct? Nothing from community planning, anything forestry.
So, Mr. Chair, for clarity, the wording should have been a bit better in the notice. We can add the minimum required side yard setback for a triplex is 3 meters. And then in the purpose.
But if it wasn't a triplex, would the performance standard on the side yard be any different?
Yes.
It would?
Yes.
Okay. And that's the issue.
And the
That's
purpose,
issue.
we can say the building will contain a total of 3 units.
Okay. So
if
if
you
you only
want
had 2
clarity.
units, you're allowed to.
Because
That's
then
the
it's a
side yard.
single family dwelling with a secondary suite.
I see.
That's what I was
Okay.
trying to get at.
Okay, so now we finally sort of understood why we're, as I said at the outset, I was confused why a no construction would talk about an existing condition, but I guess because it is different for a triplex as if it was a single family or a single family with an accessory street. Okay, that, at least we clarified that. Anyone further questions for either the neighbor or Mr. Binkowski, or is someone ready for a motion? Sorry.
So, can we get a suggested changing for the notice then?
Yes, so we'll fix the notice to say the purpose will be to convert the basement into one additional dwelling unit. The building will contain 3 dwelling units. And then for the variance, the minimum required side yard setback for a triplex is 3 meters.
Okay, so I guess the question is, does anyone have an issue with notice on that?
The notice, the variance isn't incorrect, it just could have been more robust in its wording.
Okay. I mean, I'm willing to move a motion to approve because I believe that is still minor. It just would have been nice to have that clarity on the notice, but anyway, I believe it certainly meets the 4 tests. It's just, as I say, just a clarity issue. Thanks.
Thank you, Mr. Komarek. Seconder for that motion? Mr. Palmer? Thank you. All in favor? Okay, unanimous. The application is approved. So I guess, as Mr. Binkowski said, if there's going to be more of these coming, a lot more applications, perhaps that staff, the zoning examiners will do a better job of identifying it. Perhaps they can be advised of the change that resulted from the hearing. Okay. Next application is item number 6, 6 Amber Crescent. It's an application to construct a new detached dwelling and a new detached ancillary structure, a pool cabana in the rear yard with, how many variances here? Where's the variances? I didn't write down how many variances.
4 variances.
4 variances, and we have on this application planning conditions of approval to construct as illustrated with respect to the side yard setback and the roof eaves encroachment. Transportation has no condition. Urban forestry wants condition number 1. And my question is, it says the detached dwelling. It doesn't say whether it's a detached garage, an attached garage, or no garage. So perhaps we can hear something on that from the one speaker, Matthew Suriano, the agent for the applicant. Is there anyone in the room here on item 6? Sorry, on item 6 Amber Crescent? No. Okay. So it's just Mr. Suriano.
Good morning, Mr. Chair and members of the committee. My name is Matthew Suriano from Suriano Architects, and we are the architects for Mrs. Daniela Bacchio and Mr. Arsenio Medeiros in relation to the variances being sought at 6 Amber Crescent, North York, M6L 2R6. So it is a single family home, so a detached dwelling with a attached garage. I do have a small presentation, if you would allow, just outlining the variances.
Sure, go ahead.
So we are seeking a total of 4 variances to the zoning standards to accommodate our proposal, which is to construct a new detached dwelling and new pool cabana located in the rear yard. The requested variances are for the detached dwelling are as follows. The first variance is in regards to the side yard setback requirement on the southeast lot line. The zoning bylaw requires a side yard setback of 1.8 meters, and the proposal is seeking to maintain the existing dwelling's reduced side yard setback of 1.2 meters. Because the lot line is pie-shaped, the variance is only needed for the front corner of the home. As the lot gets narrower to the street, the variance then is only at the southeast corner of the home, and the majority of the house complies with and actually exceeds the minimum side yard setback requirement. The reason we are seeking this variance is because the proposal seeks to reuse the existing home's foundation walls for both economic and environmental reasons. The second variance being requested is tied to the first and is in relation to the required roof easement setback at the southeast corner of the dwelling. The roof eave can encroach into a side yard setback by a minimum of 0.9 meters. However, because the home is already in the setback, it encroaches 1.22 meters. The proposed eave is located then 0.58 meters from the property line, only at the pinch point. Similar to the side yard setback, this is driven by the reuse of the existing foundation walls and only occurs as the property line narrows towards the front of the home. The remainder of the eaves along the south yard setback of the home comply with the requirement. The third variance being sought is in relation to the main pedestrian entrance height. The bylaw notes that the first floor height may be no higher than 1.2 meters above established grade. The proposed home would have a first floor height of 1.41 meters. We are asking for an additional 0.21 meters, or approximately 8 inches in additional first floor height, so that we can maintain a consistent and uninterrupted headroom at the basement level instead of underpinning the existing foundation walls. Lastly, the fourth variance for our proposal is in relation to the maximum permitted width of the driveway. The bylaw notes that the maximum width to be 3.2 meters. The current home's driveway and curb cut has a width of 4.65 meters. We are seeking a variance to maintain the existing driveway width as is. Reworking the driveway was actually not intended as part of the scope of work for this project. So in the context of the neighborhood, the variances we are seeking exist both in the existing built form and in new homes that have been approved by this committee. Thus, the proposal in front of you will maintain and enforce the character of the neighborhood. We would like to note that the city planning staff has been satisfied with this application and have no objections to the variances. This is confirmed in the staff report dated June 28th that was submitted to the committee. In addition, there is also a memorandum from Transportation Services dated July 13th, noting that they have no objections to variance number 4 regarding the existing driveway width. We do understand that Urban Forestry has asked for a standard condition regarding the submission of applications to permit the removal or injury of trees where applicable. The owner is fine with this condition. And finally, I'd also like to point out that in our materials, we have provided 4 letters of support from the neighbors on Amber Crescent. Most importantly, we do have a letter of support from the neighbor at 8 Amber Crescent, where the side yard setback variance is being sought, and that's the adjacent neighbor. Therefore, in our opinion, the 4 variances before you do not result in any adverse impact and represent good planning. We believe that the variances are minor. They are desirable for the appropriate development of the land. They maintain the intent and purpose of the zoning bylaw, and they maintain and intent the purpose of the official plan. With that said, we would respectfully submit that the 4 variances being requested meet the 4 tests under Section 45(1) of the Planning Act and should be approved. And I would like to thank you for your time. I'm happy to answer any of the committee's questions, or if need, review any of the submitted supporting material.
Okay, almost exactly 5 minutes. Thank you, Mr. Suriano. You didn't, so it looks like from looking at the plans, there is an attached garage, correct, to this dwelling?
There is an attached garage,
so I'm
yes.
just wondering more, like when I go through my notes and I go DDAG, and I went, whoop, no, it didn't say that, it just said DD. So why did it not say that it is an attached garage? I assume that's not a notice issue?
That is not a notice issue. There's no variances pertaining to the attached garage, but there is attached garage with a portion of the home above it.
Okay. And the other thing is the planning condition. I assume you're okay because it looks like the eve encroachment and the side setback are only some pinch points and not the whole. So they would like that. I assume that's acceptable to you and your client?
That's correct, yes.
Okay. Members, any questions for Mr. Suriano? Mr. Taylor?
Yes, Mr. Suriano, I think you answered my question, but I didn't really retain the answer. Could you please tell us what the existing southeast side lot line is for the existing home? It's not clear. It's not clear from the survey.
Yeah, so the existing setback as it currently stands for the existing home?
Yep.
Is 1.2 meters. So we're seeking to maintain that existing setback because we're using the existing foundation walls. There will be new construction above grade, but because those existing walls are in place and we'd like to keep them for both economical and environmental reasons, we don't have much play in terms of where we can put that new wall above grade.
Okay, thank you.
Okay. Any other questions? Okay, someone ready for a motion?
Yeah, I'm good for a motion if there's no more questions. I believe the application does meet the 4 tests. There's no FSI requirement. There's no height requirement. I would like to move approval subject to forestry condition 1 and subject to the planning condition tying to the site plan.
Okay, thank you, Mr. Kamarik. Seconder for that. Mr. Taylor,
I'll
thank
second.
you.
Thank you.
All in favor? Okay, it's unanimous. You have your approval. Thank you, Mr. Suriano. Okay, let's do maybe one more and then we can take our morning break. Item number 8, it's an unopposed application, 19 Orly Boulevard. It's it's to construct a new detached dwelling with an attached garage, and there are 10 variances. We have urban forestry looking for conditions 2 and 3. We have the revised site plan, we have the plans, we have a revision email from the applicant showing that the driveway is shown on the site plan, some discussion about that. We have supporting material being a presentation, plus comparables, photos and some sketches. And in planning is looking for a similar condition of approval to construct as illustrated. And the speaker on this application is Andrew Palumbo.
Good morning, Mr. Chairman. Can everyone hear me?
Yes.
Oh, fabulous. All right. Good morning, Mr. Chairman, members of the committee, and Committee of Adjustment staff. My name is Andrew Palumbo of Ian Hall Planning Limited. I am the planner and agent for 19 Orly Boulevard, and my address is 38 Betty Nagle Street in Toronto, Ontario. I'll try to be very brief in my presentation to the committee this morning. Again, there is no opposition to this proposal, as well as positive city staff reports. And on that front, I would firstly like to note that there are no issues with any of the proposed approval conditions from city planning staff and city urban forestry staff based on our review, as these are very standard conditions. Secondly, I chose to submit a photo inventory in support of this proposal in order to give a more clear visual sense of other similar examples of rebuilds in this specific neighborhood, as it provides a quick snapshot of the regeneration that has already occurred here, because ultimately this is a neighborhood characterized by very large, very deep lots, have the ability to accommodate larger rebuilds, although there is a vast range and mix of housing overall in this neighborhood. Although summarized on the last page of the photo inventory that was provided, in my opinion, the variances required to implement this proposal are appropriate and will result in a built form that respects and reinforces and is in keeping with the existing character of this neighborhood as required. The requested variances will not result in any adverse impacts of a planning nature on the surrounding area. So overall, it is my opinion that the proposed minor variance application at 19 Orly Boulevard meets the 4 tests for a minor variance under the Planning Act, represents good planning, and should be approved by this committee. And happy to answer any questions on this proposal. And thank you very much for your time this morning.
Okay, thank you, Mr. Palumbo. Members, is there anyone in the room here here on 19 Orly Boulevard wishing to make submissions? No? Okay. Members, any questions for Mr. Palumbo? Mr. Taylor?
Yes, Mr. Palumbo, could you please clarify what the existing east and west side yard lot line, side yard setbacks are? Yeah.
Yeah, it's 1.2 meters on either side, and that is actually one of the proposed setbacks is 1.2, and others 1.21, so a slight difference, but essentially effectively meeting the existing maintaining the existing setbacks.
Thank you.
Okay. I had a question, a similar question, but with regard to the front yard setback. I'm trying to visualize. There's a red line on your drawing. What does that red line indicate on your site plan?
I will pull that up. Give me 1 second, Mr. Kemrick.
And I guess it's the same question is, you know, how does that relate to what the current situation is?
Oh yeah, I could confirm the existing front yard setback is 10.6. The proposed is 8.82, and a lot of that is a result of the front porch because it has to be factored in and taken into consideration, as also that's reflected in city planning staff report comments. I'm just trying to get a sense of this red line.
Right, so the bulk of the proposed structure is going to be compliant with the setback. It's really just the porch.
That's
and
correct.
underground
That's correct.
element.
It is the porch. Yes, it is the porch that factors in. The same sort of principle actually applies to the rear as well. The main reason the building length gets pushed out a little bit is because of it in the internal. That's an eating area as part of the kitchen.
Yeah, okay, because it aligns with the
neighboring.
neighboring houses, and that's why I just wanted to clarify that.
Yeah, absolutely. Yes, that's correct.
Okay, and I'm assuming that's why they're.
And looking at the red lines, yeah, I've zoomed in, and that seems.
Yeah,
to
and
be
that's
the
why
case,
I'm
just to show
assuming
the
that's why they're
windows.
tying you to plans.
Yes.
Okay. Thank you.
Okay, any other questions?
Sorry, I've got a question. Mr. Palumbo, you've submitted a letter, I believe, to transportation dealing with the existing driveway widths. What date is that site plan?
The ones sent to the ones that was sent to transportation staff.
Yeah, okay, and what I'm getting at is, planning have asked us to tie our approvals to a site plan dated May 30th, but it's specifically regarding length, depth, and front yard, so I don't think that will impact.
Yeah, that's
you
correct. That
submit
was
a
the
different-
clarification regarding. Yeah, you're correct, Mr. Palmer. That was a clarification just to show transportation staff what the existing driveway width was. And in fact, it's actually gotten a bit smaller as a result of this proposal. But that is why it was just a more of a clarification matter that it won't impact the substantially in accordance condition as requested by planning staff.
Okay,
It was just more. It was a clarification on the site plan.
okay, thank you.
Okay. Any other questions? And if none, is someone ready for a motion?
Well, since I'm the only one that didn't ask a question, I'm going to make the motion. I believe this application meets the 4 tests under the Planning Act and move for approval, subject to community planning's condition that it be tied to the architectural plan submitted on May 30th as it relates to building length, building depth, and front yard setback, and subject to urban forestry conditions number 2 and 3.
Okay, thank you, Ms. Alderson. I have a seconder for that. Mr. Taylor, all in favor? Okay, have your approval, unanimous. Thank you. So with everyone's permission, perhaps we'll take a 15-minute morning break. We're coming back with item number 9, 12 Hartfield Court. There are 3 speakers on that. I don't know if there's anyone in the room as well. I'm just going to ask Marin Zazuni over the break to, we're going to want to hear how this application differs from the application was refused back in March as part of the presentation, March 9, 2023. And, okay, so we'll return, what time do you want to return?
11:50, Mr. Chair. Thank you.
11:50?
Or 10:50, I apologize, 10:50.
10:50, okay.
Yeah.
We'll see you then.
There's nowhere to get coffee other than Tim Hortons.
Yeah.
Not here, not in Surrey.
Okay. Okay, welcome back. Our next application is an item number 912 Hartfield Court. And it's an application. We have a revised notice for the application with changes made, revised agenda dated June the 26th. So there's this is for a detached dwelling with an attached garage with 8 variances. And we had a previous decision in March 9, 2023 on this application, which was refused. We have urban forestry looking for condition number 3. In the additional materials, we have some support letters, and I think 1, 2, 5. We have 11 letters of objection. And we have supporting materials, which I'm sure we'll have on the board during the applicant's presentation, including photos and sketches. Or sorry, that was for the last application. We do have the covering letter and a little bit of a confusion what urban forestry, because we have Ravine's letter talking about urban forestry condition number 1. So perhaps we'll want to hear about that. And the applicant is Maren Zabzuni, agent for the applicant, as well as we have the neighbors at 32 Hartfield and 4 Hartfield Court registered.
Mr. Chair, I'd like to bring to your attention that the area resident that is virtual, and the area resident that is present.
Okay, thank you. And Mr. Zabzuni is also virtual, correct?
That is correct, Mr. Chair.
Okay, Maren Zabzuni, welcome back. And sir, as I mentioned before the break, if you can just walk through how this application, first of all, we have the revision, which I guess one of the variances went down by 0.5 meter, the front lot line, otherwise it's the same. And just to go through in your application how it differs from the refusal back in March.
Absolutely. So good morning, Mr. Chair and committee members. Maren Zabzuni at 1140 the Queensway. So I'd like to kind of start with how this differs from the previous application. Essentially, we were previously refused as we did not gain support from city planning. They felt that the house was a bit larger than we're comfortable to support. And one of the reasonings was with the smaller lot depth compared to most of the neighbors. Nevertheless, we since went back and worked with city planning for this application that you see here today. And we worked very closely with them to ensure that they were very supportive in this application. So the changes essentially on a high level is we reduced gross floor area, removed building length variance, removed the front porch encroachment variance, removed the chimney encroachment variance. We reduced the proposed lot coverage variance. And I can go into detail of what that looks like right now, but briefly. So essentially, starting with item number 1, the maximum gross floor area. The maximum allowed is 165 meters squared plus 25% of the lot area. So right now we reduced, including the garage, the proposed gross floor area is plus 35.76%, which is 249.03 meters squared. And essentially, we're proposing a floor space index of 0.59 meters percentage. This is well within other approvals in the area. And again, the house itself, I want to note that it's actually below 4,000 square feet living space, not including the garage. The zoning here does include the garage area. And I want to reiterate that the lot here is shorter than most of the lots in the street. So the house is generally even smaller than many of the approved and existing builds, new builds in the area. It's just that the percentage-wise, it seems a little bit higher in reality, just because of that lot size. Nevertheless, we reduced significantly from the previous hearing. Item number 2, lot coverage. Again, that's fairly minor. We're proposing 34.3%, where 33% is allowed. So there's plenty of existing build forms and other approvals, even with a higher percentage approved. We feel this variance is minor in nature. Item 3 and 4 are essentially duplicates. They both speak to the side yard setback. And we're proposing 1.5 meter on each side. However, past the front portion of the proposed dwelling, which you can see on the site plan, the house width is actually reduced even further, meaning that we comply and it's a greater side yard setback variance on both sides, essentially, or pardon me, on the left side. And I would also like to reiterate that this is actually an improvement compared to the existing home, where the side yard setbacks are smaller on both sides. So with this new build, we're improving this variance, and this is very common in the neighborhood of 1.5 meters at both sides. So this speaks to item 3 and 4. Item 5 is where we work with planning again, where we brought it down or improved it to 8.97 meters. So I would like to emphasize that this front yard setback actually lines up with a neighbor on the left, 16 Hartfield. And we work closely with planning to make sure that the homeowners do need some of the backyard space, because as I mentioned, the backyard is a bit shorter than other lots in the area, but we compromised to make sure that city planning was satisfied with this. We didn't want to ask for more than they were comfortable with. So we feel that this is a very respectful variance where we're lined up with the neighbor. We're not asking for much. The homeowners do need as much backyard space as they can get. And also this proposed variance is even more improved compared to 18 and 20 Hartfield, which is right beside 16 Hartfield. So it's even less than that. And I wanted to make a note of that. And then lastly, item number 6 and 7, which speak to building height. So the allowed building height for slope roof is 9.5 meters. We are proposing 9.5. The reason we don't comply is that at the very top of this slope roof design, the flat area is a bit larger than allowed. So it's more of a technical variance. City planning understands that and have no concern with it.
Mr. Zimzumi, can you please wrap up, because you're
Yes.
reached the 5-minute point. Thank you.
There's other dwellings that have been approved for a higher building height with a slope roof, and we feel that this is minor in nature and represents what's been approved in the neighborhood. Thank you.
Okay, thank you, Mr. Zimzumi. I'm just looking at the location map. You mentioning that the lot is shorter or smaller than I'm just looking, it looks pretty consistent with 10, 16, 18, or is that just how it's depicted? But I think you did explain something about the reason for the variance is that it's a shorter lot than the other lots.
Yes. If you look at the rear property line, it comes in and meets right at 12 Hartfield, where you have an angled property line, and in the middle, if you could even see this on the site plan too, you'd have to zoom in, where that's the shortest end, because they're meeting on an angle, the property line cutting through.
Yeah, it looks like the city boulevard portion may be bigger as it goes around the curve. Perhaps that's where you get it as well. Okay, anyone else have any questions for Mr. Zimzumi before we hear from the neighbors? Okay, so the first...
My question really had to do with building height. That was my principal concern. And just, can you give us some examples in the neighborhood that are comparable?
Yes, so building height, we did update or sent in the research chart, but essentially 30 Hartfield was approved at the same building height. 16 Edenbridge Drive was approved at 13 meters. 7 Hartfield Road was approved at 11.89 meters. 413 The Kingsway approved at 10.98 meters. 81 Wimbledon Road, 10.17 meters. 14 Hartfield Road, 10.11 meters. So there's several properties that were approved for even higher building height. We are at 9.5 meters.
And are these for flat roofs in all these examples you're telling us about? Because you have a flat roof, right?
30 Hartfield is for flat roof. Some of the majority of the other ones are for slope roof. I'd have to review in detail which ones are for flat.
Yeah, I'm saying you'll agree with me that the ones that are relevant are ones that have a flat roof height. Otherwise, it's a different performance standard. You're looking from 6.5 with a flat roof. The slope roof is different, but. And I guess at this point, community planning was opposed last time. They are not. Have they written anything in support, or they're just silent?
We spoke with them. We have email correspondence and phone calls. They're
Okay.
in support of every single variance here. I can confirm that 100%.
Okay, yeah, it would have been nice to get, especially since, within the last several months, there was a refusal on the property, but they haven't weighed in with any opposition to it. And you said you have told us you've worked closely with them. Okay, any other questions? Or if not, we'll hear from the two neighbors we have. One, we'll hear from.
I just have a comment. I'm not sure if the chair mentioned this in his opening remarks, but there are 5 letters of support in the additional materials, and one of them happens to be from the immediate neighbor, and the other one happens to be from the neighbor directly across the street from this property. Is that correct?
Yes, I believe so. They're in close proximity to the house.
Thank you.
The addresses I made note of are 27, 11, 18, and 10. So 10 would be right next door.
And 11 would be right across the street. Okay, thank you.
We don't know about the rear, but there are, again, 11 letters of opposition and several
9 is
two
directly
speakers.
across the street, 11 is Little Kitty Corners.
Yeah, okay. And we didn't hear about Mr. Zeb, but he ran out of time. Perhaps in his rebuttal, he can mention we'll have to clarify what the urban forestry condition is, whether it's 3 or 1 or 3 and 1. So the first neighbor, it will go in the order we have, is the one who's virtual, is Peter Sallow at 32 Hartfield, and then we'll hear from Bruce Mack, who's in the room.
Can you hear me?
From number 4. Yes, sir. Welcome.
Yes, sir. Good morning. Good morning, members of the committee. Nice to see some of you again. So my name is Peter Salo. My family and I have lived at 32 Hartfield Court for 19 years, and we would like to express our concern to the proposed variances for the construction of a new home at 12 Hartfield Court.
Sorry, can you just hang on to staff and we get his letter up on the board while he speaks?
Sure.
Thank you.
Thanks. And while you're getting that letter up, first point I want to make is we live right next door to 30 Hartfield Court. Sorry, that was not presented as a flat roof. That was represented as a pointy roof design. There was a lot of opposition to that roof height before. And that's why, again, we're opposing, one of our big concerns is the roof height itself. So should I wait for you to bring the letter up or should I just go ahead? Because my clock is ticking here.
Yeah.
Mr. Chair and members, we are looking for the letter, but
We'll give you, we have a lot of them, so.
I'll speak to it. Let me keep going. So
I have it here. It's the letter, first letter. It's the first
okay.
letter, or so the second one? Letter 2.
I only gave you one letter.
No, I'm saying we have a bookmark with all 11 letters, and they're bookmarked, and that's the second one. Just letting staff assist them in finding the letter.
Okay. When you do find the letter, can you restart
Yeah, it's
the
up there.
clock? In fairness? It's up there. Okay, but the clock is 4 minutes. Can you
Yeah,
restart the clock?
let's restart the clock, please.
Thank you very much. Much
Like
appreciated.
at a football game.
Okay. Okay, thank you. Okay, so the first area of concern is actually with the maximum permitted height. So according to the bylaw, the maximum permitted height of a flat roof is a dwelling is 6.5 meters, right? And the variance request is for a height of 9.5 meters. So that represents a 46% increase in the allowable height for the structure, right? So if you have such a flat front house like that, it makes it look massive compared to other houses on the street. And it's going to adversely impact the balanced look of the homes on the rest of the street. If you slice it the other way, if you consider the wall height, you've got a proposed mansard design. And that's a bit deceiving because basically what you're doing is you've got a flat roof and you've got a bit of a perimeter around there. It's got a bit of an angle to it to get around the flat roof limitations. So if you compare the 7.85 meter proposal to the 6.5 limit for a flat roof, this still represents a 21% increase in the height over the allowable height limit. It's a 12% increase with the mansard. And if you just take the regular flat roof increase, it's a 21% increase. Both are substantial. And, this is not, either one is not a minor variance. Second item I want to bring to your attention is regarding the gross floor area. So permitted gross floor area is 339 meters squared, and the variance request is 414 meters squared. The gross floor area of the existing structure is 121 meters squared. So the proposed gross floor area variance represents a 242% increase over the existing structure and a 22% increase over the maximum allowed gross floor area. Once again, a huge increase either way you cut it. The third item I would like to bring to your attention is the front yard setback. So the application for the front yard setback has been approved, but still exceeds the bylaw by 0.53 meters. All the other homes comply with existing front yard setback rules, putting the front of 12 Hartfield Court out of alignment. You've got to take into account the curvature of the street. You just can't line it up to the house next to you. That's not proportional. So it's very important to preserve the current streetscape for the street. Allowing this front yard setback variance to be approved sends a precedent for future builders to bypass this front yard setback requirement, and that could lead to further misalignment of the streetscape for Hartfield Court. And if you look into areas like Willowdale, and what you see there is you see that streets have gone out of control. You've got massive houses beside bungalows, frontages exceeding other ones, and basically the whole look of the street has been ruined. And we're trying to preserve that. We live in the Kingsway and Humber Valley areas, and preservation of the looks and streetscapes of our streets is highly, highly important. So basically the City of Toronto Code is in place for a reason. There are an overwhelming number of requests to violate code with view to constructing overwhelming structures that do not fit in our street. We rebuilt our home in 2004, and when we did it, we specifically stayed completely 100% within all the bylaws. We could have requested variances to have a bigger home, but we considered our neighbors. We did not want to impact them adversely. We wanted to respect their privacy and the character of the Humber Valley neighborhood itself. So, in summary, we strongly urge you to consider the concerns we have raised regarding the proposed variance for the construction of 12 Hartfield Court. The proposal does not meet the 4 tests for minor variance. We believe there are alternatives to the proposal that would be more in line with the zoning bylaws, would minimize negative impact on surrounding properties. And as I agree with the committee, you still have a huge lot. You can still build a large, substantial home, and with the right architectural design, you'll have all that square footage you need. Thank you very much.
Okay, thank you, Mr. Salo.
Okay, thank you, Mr. Salo.
Okay, we're getting some feedback.
Mr. Chair, that's on their end, but I've gone and muted them at this moment to try and avoid that.
Okay, thank you. Members, any questions for Mr. Salo? Okay. In that case, we have our first speaker in person for, well, we had one earlier this morning. So Bruce Mack, and I believe his letter is the last letter on our bookmark with references and to, we'll hear about OMB matter for number 3, I assume as part of the presentation. So Mr. Mack is at the podium.
Actually, I'd like my presentation up, please. Yes. Yeah. I don't know if it's going to pop up.
Yeah, it's the last one on our list.
There we go. Okay. Good morning. I'm Bruce Mack from 4 Hartfield Court. My wife and I still oppose this application. Our concerns regarding street view and establishing an extreme precedent remain the same as last March. Buildings outlast their owners, so these issues concern all future residents as well. The next slide shows the 100+ homes in our neighborhood. Next slide, please. The solid red box shows number 12. The area does not need dramatic change to attract investment. Owners have continually upgraded their homes over the decades while reinforcing the original pitched roof street pattern. Recent activity number 12 included number 9's completion of construction this year and number 7's unopposed variance application last year. The next slide shows a similar building to the proposed 12 and recently approved 30. We simply wish this building to fit onto our street rather than stand out and dominate it. The next slide shows existing 12 as one turns onto Hartfield Court from Earl York and also from Southway. The next slide shows a closer view as if you're walking down the street. The next slide begins our review of 12 with respect to our neighbors and the street pattern. To evaluate height, a recent tribunal settling the flat roof zoning law bylaw disputes provided an approach to quantify the misalignment of 12 with respect to the streetscape. The approach is to determine how well the top of a flat roof is aligned with the eaves of a pitch roof. The chart shows number 12's proposed wall exceed 10's existing walls, even at the same elevation. The excessive demand of 12 is also apparent if we compare it with a new build of number 10. In this case, 12's proposed walls will still exceed the new 7-meter walls of 10 by almost a meter. With respect to variance comparables, zoning gaps have resulted in an incomplete review. The applicant compares 12's roof height with pitch roof buildings, while zoning reviews a flat roof building. Thus, neither party flags the wall height requirement for pitch roofs. The proposed number 12 has a box-like flat roof parapets, but nowhere is it flagged that these will exceed the limiting requirement found in less restrictive flat roof zones. If this variance is granted, we also fully expect all future pitch roof rebuilds will have a solid case to demand these excessive wall heights as well. Thus, we believe the height variance approval will destabilize our street and does not meet the intent of zoning. The next slide shows a top view of 12 and its immediate neighbors 10 and 16. Note the yellow requirement line for 12 already moves the building forward. The proposed red line aligns the large two-story 12 with a one-story garage. This makes no sense to us as it moves the highly visible building 1 meter ahead of two-story number 10 and 3 meters ahead of 16's second-story window. This impacts the neighbors as well as the street view. In addition, it removes even more treasured front yard space. With respect to variance decisions, the applicant's comparable list clearly highlights that 12 will set a new precedent for the neighborhood, as the actual 33 decision referred to by the applicant shows that the variance was only 0.2 meters, and the 18 Hartfield Road decision was for a garage-covered porch structure aligned with and having a lower roof height than its neighbors, not an extra tall two-story residence in front of the neighbors and impacting the street view like 12. The applicable decisions and pictures are provided in a reference material. Thus, we believe the front setback variance should be refused. The next slide shows how moving a house closer to the street will make the building appear taller. In this case, the red line shows how someone walking by will perceive the wall height of 12. The tall two-story wall will extend from the building on one side to the building on the other side. Remember, the street observer will also see the box-shaped roof on top of this red line. With this height and width, 12 will dominate its neighbors and the street view. Even if 10's walls were raised to the yellow zoning line limit, 12 will dominate. The next slide highlights the actual building changes since the March refusal that relate to our issues. There has only been a minor change in length. Simple changes were not attempted to adequately fit the building onto the street. This proposal simply has no comparable. Even the GFA comparable for 20 provided by the applicant is not relevant, as this decision showed no associated height, front, or side setback variances. Thus, 12's requests are excessive, and we believe this is a major, not minor decision. In addition, we are also very concerned that this 12 decision, along with the 30 decision, will further establish an excessive wall height precedent on the street, that this is not flagged by zoning, highlighted by planning, and decided on by the variance committee. This is a problem. We are very skeptical of planning support for this project as well. They are silent. I think they want this committee to decide. For these reasons and more, we believe this proposal still fails the 4 tests.
Thank you, sir. Almost exactly 5 minutes. Appreciate it. Anyone have questions for Mr. Mack? Okay, thank you for your presentation. And having said that, I guess we'll turn it back over to Mr. Zabzuni for his rebuttal to the 2 neighbors.
Yes, thank you for that. I'll happily speak to some of those concerns. So maybe we'll start with the front yard setback. The image that was showcased in the sketch showing where 12 Hartfield would be located is incorrect, as we're actually lining up with the neighbor on the left, 16 Hartfield. And if you actually look at whether it's that image or the site plan or site map, the curvature of exactly where 12 Hartfield and the immediate neighbors are located is very minor. So that proposed dwelling being lined up with 16 Hartfield is very compatible with the neighborhood. And planning agrees with this. We've had detailed discussions about this variance. So we made sure that it was revised based on the waiver exactly to address any concerns or future concerns from neighborhood. In terms of building height, essentially, this is still a traditional home. There are modern homes and traditional homes that are approved and built in the area. It's 9.5 meter building height with a slope roof. You could see that also on the roof plan and the elevations. You're happy to present that. And it's not the first application that's been approved with that. It does fit the area, the neighborhood, and it does show from street level, from eye level, the massing as a traditional home, as you do not see the top flat portion, you see the slope roof portion of the dwelling, as you can see here. The flat roof is slightly over the 50% and essentially dictates this is a technically flat roof. However, planning recognizes that we are proposing a traditional dwelling with a slope roof, and the massing from streetscape is compatible with that. And again, there's other dwellings that have been approved and built for higher building height where the massing is larger, and we're made sure to be very respectful with that. The other thing I want to mention is that on our last hearing, when we proposed a bigger home and more variances, most of these neighbors that sent in a letter of objection had actually no comments or concerns when we were proposing a bigger dwelling. So it's a bit disappointing to see how much effort we've put to reduce the dwellings and have this some of these letters put in. The homeowners have owned the property since 2019. There was even a letter saying that he owns 3 developments in the area, which is completely false. And they asked us to make a point during this hearing to reiterate that, as we believe there may have been negative influence to obtain some of these letters of objection, which is very unfortunate, as the homeowners have lived there for years now. They love the neighborhood. And we put a lot of effort working with planning to ensure that this proposal is very respectful to the neighborhood and that it meets the 4 tests. And we strongly feel that it does. The immediate neighbors around this proposal still support this application. So we feel that we've put this great effort to make it work. If there's any questions I can answer, I'm happy to. But overall, I think we have a very respectful application.
Okay, thank you, sir. Members, any questions for Mr. Zabzuni or the 2 neighbors? If not, we'll take it into committee for a decision. Any discussion and or motion?
Yeah, Mr. Chair, can I just put something out for our consideration?
Absolutely.
This panel heard a proposal on this property on March 9th. And Mr. Palmer and Mr. Komorek, you sat and participated in that decision. My view is this is not substantially different from what we had before us in March. The gross floor area is 30-odd square meters less. Coverage is the same. Side yard variances are the same. Front yard setback is actually 1.2 meters worse. And the height is the same. So my inclination on this right at this point is not positive, but I'd certainly like to hear the views of others. I could frame a motion at some point, but I think I'd like to hear some commentary from my colleagues.
Colleagues?
Well, I still have a concern on the height variance, which I had a concern of before, and as you say, it's not changed. The setback, I can understand some rationale on that, but I'm still stuck on the height.
So I think, as Mr. Zabzuni said, the one area they did make changes was on the length. Is that where they cut down?
Yeah.
Just trying to pull up the previous decision. Okay. Any comments from based on Mr. Taylor's commentary and perhaps motion?
Yeah, I think incrementally each variance appears like not much, except for maybe the height. The height seems excessive, but collectively together they just look like an overbuild on this lot to me.
Okay, I think as Mr. Max said, he was distinguishing one of the Mr. Zabzumi's properties he mentioned to justify, I think, the GFA, and he says, yeah, but that one didn't have anything other than GFA, which is obviously, when we look at the number and if you're stretching the envelope, if you just stick on one, perhaps that's accessible. Interesting that community planning did not weigh in, as they did, I believe, last time, back in March on the previous application. So the issue is, as I stated at the outset, members are going to want to see how it differs from the one that was refused. And we've heard on that. So again, I guess waiting for a motion. Mr. Taylor?
Yes, thanks, Mr. Chair. As I said, I feel that the variances, the adjustments that have been made to this proposal since March are, in my mind, insignificant. This panel felt that this proposal was overbuilt 4.5 months ago. I still believe it is. I believe that it does not meet any of the 4 tests under the Planning Act. I commend the speakers today for making that point, which I fully agree with. So my motion would be on the grounds that this proposal does not meet any of the 4 tests under the Planning Act. The motion would be to refuse.
Thank you, Mr. Taylor. Second for Mr. Taylor's motion.
I'm happy to second that motion. I believe it is an overbuild for the site.
Okay. Thank you. All in favor? It's unanimous. The application is refused. Thank you, Mr. Zabzuni, and thank you to the neighbors, Mr. Mack and Mr. Sallow. Okay. Our next application is item number 10, 46 Willingdon Boulevard. It's an application to construct a 2-story rear addition and a new detached garage in the rear yard. There were 5 variances. There are now 4, and one of those has been revised, the FSI from 0.64 to 0.63. We have an applicant email enclosing the revisions. We have an arborist report, support from 971 Royal York, opposition from a lawyer acting on behalf of 48, who will attend the meeting, from Mills & Mills LLP, and believe that in the additional materials, we have submissions from number 44 on the other side for John Fabello.
Mr. Chair and members, I'd like to bring to your attention both area residents that want to speak. In this case, the lawyer and area resident are present on the call at this time.
Okay, and Mr. Eagleman is in person. So that is one of our most prolific presenters, and we've had a voice, and now we get to see him in person.
Yes, good morning, Sir
Good
Chair.
morning. So, and we also, last thing I'm going to mention, urban forestry looking for condition number 2. Okay. And so we have 3 speakers. Both adjacent neighbors are either going to be speaking or by their representative. Okay, Mr. Eagleman, welcome.
Yes, good morning, Sir Chair and committee members. David Eagleman, Design Plan Services, 900 the East Mall Suite 300. I am a senior planner here on behalf of the owners. And through you, Mr. Chair, if you would like, I can go through the revisions to the variances.
I think there was just the 1 revision, or there 3 revisions?
There was 3 revisions, sir.
Well, as part of your presentation, your final form of what's before us, so the efforts you did to eliminate a variance and reduce 3 others.
Yes. So through you, Mr. Chair, I'll just quickly note that the FSI was slightly reduced to 0.63 times the lot area. That is more a function of the reduction to the length, which was the main concern that we discussed with planning staff. The length, which is variance number 4, was reduced to 17.87 meters. And the variance for the garage height, that would be variance number 5, that was eliminated. So before getting into the variances, I will note that we have consulted with planning staff and we have made those revisions to their satisfaction. I have also reviewed the memorandum from Urban Forestry, and I find the standard forestry condition number 2 to be acceptable. I am not aware of any concerns from any city departments or relevant agencies regarding this application. And I have also reviewed the objection letters from the surrounding neighbors, and I understand the concerns expressed. I respectfully disagree with the comments made within those letters, and I will provide my justification for the variances and why I disagree. So regarding the proposed FSI, the proposed lot coverage, that will result in approximately 6.68 square meters or 72 square feet over what is permitted as of right. It is a very minor increase in lot coverage and will be practically imperceptible as compared to an as of right lot coverage on the subject property, and will have little to no impact further than what the bylaw already contemplates. And there have been a number of approvals in the neighborhood. For the sake of time, I won't go through them, but I will note that the average of those approvals is 37.0 0.05%. And further to this, the proposal is compliant with all landscaping requirements, which further demonstrates the appropriateness of the lot coverage, in my opinion. Variance number 2 pertains to the proposed FSI/GFA, which has been slightly reduced, again, more of a function of the reduction to the building length. And the additional massing will be distributed over 2 floors and will be in keeping with the existing character of the neighborhood. Specifically, the additional massing is proposed entirely at the rear of the subject property, and there will be little to no impact specifically on the streetscape. And the proposal will maintain the existing character of the front facade of the existing dwelling facing Willingdon. The proposal also includes maintaining the sloped roof design and is compliant with the maximum overall height and maximum main wall height, as well as I've noted, all landscaping requirements, all setback requirements, save and except for the north side yard setback, which I will discuss. And it is my opinion that the FSI is in keeping with the existing character. Variance number 3, which pertains to the north side yard setback, that is an existing condition that is proposed to be maintained. The proposed north side yard setback will have little to no impact further than what currently exists on the subject property. The proposed addition is intended to align with the existing side main walls of the dwelling. And if you take the 2 proposed setbacks together, the total aggregate setback is actually 2.43 meters, which exceeds the minimum requirement of a new dwelling in this zone, which is 1.2 meters for an aggregate of 2.4. And just briefly on the length, the proposed length includes an existing front bay window, which accounts for 0.77 meters of the proposed building length. And if you exclude that, the proposed length is actually 17.1 meters, so 10 centimeters greater than what is permitted as of right. And the second floor is at 17.01 meters, so 1 centimeter then greater than what is permitted as of right. So those are my comments, Mr. Chair. I'm of the opinion that this proposal meets the 4 tests, and I'm happy to answer any questions at this time.
Okay, we'll hear what the neighbors have to say. So the changes you did make, the elimination of variance 5 and the other 2 reductions, did that come about as a result of discussions with community planning, or what precipitated that?
Through you, Mr. Chair, that is correct. It was as a result of discussions with planning staff.
Okay, thank you. Any other questions? Anyone have any questions for Mr. Edelman? Okay, if not, we'll hear from the 2 speakers. The first of is counsel for Karen Bieberstein at number we'll hear where she lives. And that's Adnan Subzwari.
Mr. Chair, members, Adnan would like to be on video for this, so I'm going to go ahead and make them a panelist. Adnan, you're now a panelist, so you can go ahead and start your video by clicking the Start Video button. I'll go ahead and add you to the stage.
And we can get his letter up on the board, which is the opposition letter on our bookmark.
You'll also be responsible for muting and unmuting yourself for the next little bit.
Yes, good morning, Mr. Chair and members of the committee. Can you hear me?
Yes, we can.
Yes, okay, thank you. Good morning. I am the lawyer for Karen Bieberstein, who is a resident at 48 Willingdon Boulevard. And that is the property that is immediately
Want to start
north.
the clock, please?
Yes.
Go ahead.
So that is the property that is immediately north of 46 Willingdon. We filed submissions on July 13th, 2023, and I will be building up on those submissions. So we object primarily on the basis that this is not actually a very minor variance. In fact, it will have a major impact on the use and enjoyment of the Bieberstein's property. The rear addition is a substantial block that will add nearly 4 meters to the property. It is not set back from the sides, and that is where the variance of bylaw number three comes in, where they want to reduce it by 0.6 from 0.6 meters to 0.43 meters. I will note that is a reduction in the setback by 30%. that is not minor variance, that is a major variance. And in general, the proposal is very aggressively masked to provide maximum square footage to the property, and it does not consider the impact to the neighbors at all. Now, in my submissions, written submissions at Appendix B, we have provided pictures of the backyard just to provide you, with the committee, with an idea of the real term impact that this will have beyond just the architectural drawings. And in particular, if you look at picture 2 and Appendix B of our written submissions, you will see that the new addition will effectively extend all the way to the garage area. And this is in picture 2, which is one page down. And so what will effectively happen is that the Biebersteins will have a hulking 2-story mass looming over their backyard. It will completely block the sunlight that's coming into this space. It will reduce any and all sense of privacy because of the windows that are looking onto their backyard. Now, we note the lack of setbacks in particular because other properties in this neighborhood have built rear additions in the past, and each new addition has had a setback. In Appendix C of our written submissions, we provide the example of 40 Willingdon, which is down the street. And in Appendix C, you will see that the new addition has a reasonable setback from the side property line, and also that the length is within the current requirements of the bylaw. Now, this proposal does none of those things. There's no setback. It suggests just extending the side walls to where they are right now. And so we would submit that this is not only an aggressive massing for this rear addition, but it's also completely out of character for the neighborhood, where every rear addition has had a setback. Now, my client is not against their neighbors building an extension, but if an extension is to be built, it needs to be reasonable, it needs to be in keeping with the character of the neighborhood, and it needs to be respectful of the impact that it will have on the neighboring properties. And that primarily means that the existing bylaws need to be respected, and this application consequently should be denied. Now, we have made some suggestions in our written submissions about how our issues can be addressed, and I will leave it to the committee to consider those. One further thing that my client would wish to note is that when they built their extension, which incidentally also included a setback from the side property line, she was required to install fire shutters on the inside of the property, and she didn't see that requirement in any of the materials and wanted to point that out. So for all of these reasons, we are strongly opposed to this application for what is not really a minor variance, but rather a major variance with a major impact on my clients. So subject to any questions that the committee has, those are our submissions. Thank you.
Thank you, sir. One point you mentioned, I'm just wanted, and we'll hear Mr. Eagleman clarify in his rebuttal. I thought he said a variance 3 was an existing, just this is not a new build. This is a rear extension and a new detached garage. So I thought he said that was an existing condition, but we'll hear from him. Anyone have any comments or questions for agent for the neighbor? Okay. If not, then we'll go to the next speaker, who is the neighbor on the other side, and we have his submissions in the additional materials. John Fabello at number 44.
Morning. I'm, if you can hear me, it's John Fabello speaking. I'm happy to be on screen, so you can all see what I look like if you like.
So
I'll jump right into
Mr. Fabello, I guess it showed you re-registered advising you were going to be on audio. I don't know if it's too late at this point to have him.
Mr. Chair, we can look to bring him over and put them on screen if you'd like.
Sure, if you'd like.
I'm fine to.
Mr. Chair, I've gone and made John a panelist. So John, you can go ahead and turn your video on. And the start video button will be at the bottom of your screen. There you are. And I'll go ahead and
Terrific.
put you in, and
Thanks very much.
should be good to go.
I know time is tight. I know time is tight for the committee members, so I'll jump right into my submissions. So my name is John Fabello. I live at 44 Willingdon Boulevard, which is the property adjacent and south to the subject property. I've lived there for 22 years. And my submissions are twofold. My first submission is a request for a deferral or adjournment for the reasons stated in my written materials. I've acted diligently upon receiving the notice for the first time in the materials. I only had time to skim them. I'm in the process of retaining somebody who can properly and better than I read and understand the drawings. I don't need much more time to fully understand the impact of this on my property, but I am requesting an adjournment. That's my first request. I think the reason the further amendments this morning, which I'm seeing for the first time, which I don't criticize, by the way, I commend the applicant for making changes to make the property more compliant and less requiring of variances. But it's the first time I'm seeing the variances, and I see the main variance that is of concern to me, which is the building length. By the way, my submissions and concerns are similar to the ones that my colleague just expressed on behalf of my other neighbors. I see that variance is impacted. So that's another reason for me to be permitted additional time. I'll launch right into my alternate submission. I'll do the best I can making submissions based on my current understanding of the variances requested. My submissions are very analogous or similar to the ones that you've just heard. My property, a main feature of my property, subject to a renovation I did, is the family room and kitchen, which faces west at the back of the house. And it has a 180-degree view and light. It's the only place in my house that has that access other than the front. And it's the place where my family spends their most of their time. I know that these submissions would be inert if I talked only about the impact upon me subjectively, but the proposed addition at the back would cause me and my family to look into a two-story addition as opposed to what it currently is and what the room was designed for, which is to maximize access to light and to the nature, trees, and essentially the only natural part, if you will, of the property. And this addition at the back would impede that very significantly. No house in my submission that I can see, at least from my backyard, extends this far back, and therefore would not be in my submission in keeping with the rest of the neighborhood. Those essentially are my submissions based on my current lay understanding of the proposed addition. I'll conclude by saying, again, echoing the submissions that my friend just made, that the back addition is major to me. I'm concerned about the access to light, to nature, which the plan speaks of and features prominently in the plan. I'm concerned about the impact on the value of my property if all of a sudden from the main room where we spend most of our time and where any purchaser would spend their time, instead of looking at nature and instead of having access to light, they would instead be looking at a two-story addition, at least from that perspective. Thank you.
Thank you, sir. With respect, I guess at the outset to deal, before I see if anyone has any questions for you, in terms of your mention of a request for a deferral, deferrals are typically not granted readily for, at the neighbor's request, and the applicant has to, make changes or missing a variance. But for a neighbor, the standard, we acknowledge that the time provided is not a lot in terms of when the notices are set, but that's the way it is. And in terms of hardship to the applicant, having an applicant to, delay their project by, if someone can have a formal motion, but I doubt the neighbor, your reasons for a deferral are, balancing with the rights of the applicant to bring an application to have it heard in a timely manner. So on the issue of the request by Mr. Fabello for a deferral, I guess we should vote on that, as he did make the request. So
I do appreciate.
Yeah, because it's not given along. Every neighbor could cut, and really, I've seen neighbors have to really scramble to get letters together, and very extensive letters in some cases, and it is anxiety provoking. But that's just the way the system works. So on the issue of the deferral request by Mr. Fabello, can I have a motion, please?
Chair, shouldn't we hear from all parties if we're looking?
Yeah, I'm just dealing on the first issue of whether he's made a request for deferral, so whether to make it at the end of the meeting. I doubt, I'm just saying we should dispense with that at the outset. Then obviously all his claims on the merits, Mr. Eagleman's gonna respond and all of that. So I don't think Mr. Eagleman, I assume he's opposed to the deferral request, if that's what you think we should do. I assume you don't accede to that request. So I'm just saying, we don't normally get a request like that made. So it's a little unusual, but should we deal with it now or at the conclusion?
I mean, I think Mr. Eagleman should respond, and then the committee can see if there's even an appetite. I don't think we need a motion if there's no.
Okay, so in other words, I guess we can just have Mr. Eagleman make his general rebuttal to the claims on the merits by the two neighbors at this point, and just ignore the deferral request. Okay.
Yes.
Mr. Chair,
Yes.
can we, before we go to Mr. Engelman, can we just confirm that there are no more questions for the area resident that is speaking?
Does anyone have any questions based on the rebuttal? Otherwise, they'll be opened and can ask questions of anyone after Mr. Eagleman finishes his rebuttal. So at this point, no one has any questions for Mr. Fabello, or for that matter, the previous speaker counsel for the Biebersteins.
Okay, thank you, Mr. Chair. I just want to, now I got to give me a moment while I reorganize
Okay.
the.
Yes, through you, Mr. Yes, thank you, Mr. Chair. Through you, Mr. Chair, just for the record, I would not like to defer the application, as you assumed correctly. I hear the neighbors' concerns. I think what is not being acknowledged by the neighbors, and I think where the comparisons are being drawn are from what is currently existing on the subject property today, as compared to what is proposed. But as the committee knows very well, what has to be taken into consideration is the plan context as well, which is what is permitted by bylaw 569/2013. And in the city's official plan, it does speak to the fact that neighborhoods will change over time. They are not to remain stagnant. This is, I believe it is a pre-era war dwelling, and this is a minor addition at the rear that will add some additional living space while maintaining the existing character of the house, specifically, as I mentioned in my presentation, from Willingdon Boulevard. And in regards to I can't recall the name of the representative, but the neighbor to the north, the representative that made his presentation, he speaks of the length being very excessive, and I think the neighbor at 44 Willingdon is too. However, the existing building and proposed addition is actually compliant with and less than the maximum permitted building depth by 0.92 meters. So if you were to tear down this building and build an as-of-right dwelling, you could theoretically put the rear main wall 0.92 meters or just over 3 feet further into the rear yard. So that is my comment on the length. The neighbor at 48 Willingdon, he also spoke to the privacy being a concern. There are actually no new windows proposed on the second floor along the north side on the addition. There's only a replacement of existing windows that are already there on the north side. To address your question, Mr. Chair, it is the north side yard setback is an existing condition. Obviously, it's not an existing condition with the addition because that is a new addition, but it is an existing condition with the dwelling that currently exists, and the addition will maintain that existing north side yard setback. And on the south side, the existing side yard setback, which is going to be maintained, is 2 meters. And the addition is actually partially, you can see on the site plan, the addition is sort of cut out for a covered porch. And therefore, the addition is actually, part of the addition is further set back from the south side lot line, which significantly mitigates any impacts specifically to the south side in respect to the comments from the neighbor to the south. The neighbor, again, the representative for 48 Willingdon, he did mention fire shutters. That is a construction building code matter that will be dealt with through the construction process. And I'm of the opinion, it is my opinion, that this does meet the 4 tests. It is a minor rear addition, and I would like the committee to approve the application. So those are my comments, Mr. Chair. Thank you.
Okay, so what you're doing with the side, you're just, so it's already over, and you're just doing building in line, so that part will be over. And then you mentioned the other side, you're actually well in excess of the requirements. So if you were to build a new home, for that neighbor who is to the south, you could come a lot closer to, as of right.
Through you, Mr. Chair, that is correct.
And even be longer, and you're only over like less than a meter. Is that my understanding?
Correct. And the length includes an existing front bay window, which again accounts for 0.77 meters of the proposed building length and is only at the first floor.
Okay, thank you. I think we got a pretty good picture of what that's all about. So, members, any questions for Mr. Eagleman, or for that matter, either the 2 other speakers, or are we ready for a motion?
Comment or question?
Yep.
The only real issue I see here is the setback on the north side, and that setback, the difference between what is permitted or what is as of right and what is being sought, the difference I believe is about less than 7 inches.
Yes, through you, Mr. Chair, it would be the proposed setback is 0.43 meters, and the requirement is 0.6, so that would be a 0.17 meters, if my math is correct.
Sorry, I just visually I'm more familiar with.
That would be
the old
imperial.
Yeah,
I believe 0.17 meters is under a foot. It is approximately I can't do the.
My calculation was around 7 inches. I'm just not sure if that's correct or not.
Yeah, that sounds approximately correct.
Because that's really what's at issue here on the north side, because everything else would be as of right. So you could, if you set it back, let's say a foot, you would really have no variance there.
In terms of the side yard setback, correct.
Correct. Okay.
Okay. Someone ready for a motion?
No, I had just one further question. Mr. Engelman, you previously had a variance for the ancillary structure, so that's been removed now. But does the ancillary structure add coverage into the coverage calculation?
Through you, Mr. Chair, Mr. Palmer, I believe the garage does get included in coverage, so that does contribute to the coverage as well.
Okay, thank you.
Okay. Okay, any other questions? If not, is someone ready to weigh in with a motion?
Yeah, I think on balance, we are meeting the 4 tests. As I say, my only issue was on that setback. I'm not sure from a distance you could discern the difference. And the length, I'm comfortable with the length issue. If it weren't for the bay window, we'd be talking, again, a number of inches. I think it would be helpful, this is just a general comment, for applicants to submit on their site plan an outline of what would be as of right, so that then we can we can explain, or at least the neighbors have a better idea of what is being sought here. That what you're asking for is the difference between what is as of right versus what you're asking, as opposed to what is now and what you're going to. Because the difference here between what exists and what is proposed is substantial. And I therefore understand the concerns of the neighbors. But what's before us is the differential between what is allowed and what you're seeking. And in my view, that differential is minor. And I would support that. But it's less clear to the neighbors, I think, if you don't put that on there. Anyway, with that caveat, I'd like to move approval of the application.
Okay, there's no forestry or anything?
There is a
Yeah,
forestry condition,
yeah.
forestry condition 2.
Okay, thank you for that
Subject
motion.
to forestry condition 2.
Thank you for that motion. Do I have a seconder for that motion?
I'll second that motion.
Okay, in terms of what Mr. Kamara, I think that's something that they should actually impose as a requirement, that, you know, some of the architects do that as a matter of course. But it should be, you know, to make, we're in an information age, so more information you bring to the neighbors, the better. And I think that's something that's a very valuable thing. All in favor? Okay, unanimous approval. Thank you, Mr. Eagleman, and thank you to the neighbors for your participation as well. The next application is item number 11, 17 Kemp Square. And it's an application to construct, okay, where is it here? I didn't write it in my notes because it was a mouthful. Figured I could just read it off the screen. It's for constructed 2-story front and rear additions, a 2nd-story addition above the existing dwelling, and a new front covered porch. And there are 5 variances. Planning has conditions of approval to construct as illustrated regarding the front yard setback. Transportation is okay. Urban forestry looking for condition number 1. And the speaker is Eddie Perez. Actually, Mr. Perez's name is
Hello,
spelled
good
incorrectly
morning,
in
Chairman
the,
and committee members.
on the notice. It's-
On my end, I can't hear you, any of you, the members at all.
You just faded out. Are you?
Can you hear me?
Can you hear that, Mr. Perez?
Mr. Chair and members, Eddie is unmuted. Eddie, go ahead. Eddie, if you've done something recently, you were earlier fine, and for some reason, maybe you started clicking buttons or changing stuff up, but you seem extremely far from your microphone at this
I
time.
can't hear anything that the members are saying.
Oh, hit the...
We're not saying anything.
Yeah, I heard you now.
Okay, okay, I guess we're good.
Okay, now I can hear you. Okay, again, nice to hear from you guys. Good morning. I'm here for an application to build a 2nd-story addition. We're asking for, according to the zoning, is 37.5, but they took in the eaves into account because of the way the house is situated at the front. Because of that, the eaves are counting. Our actual coverage is 32.3%. Then we have a front yard setback as well, which is existing situation, because we're trying to maintain the existing house and build within it. And then we also have a driveway variance, which transportation is okay with. It's a little bit over 3.2. We're asking for 4.27. I feel that our variances are minor in nature and it meets the 4 tests. And if you have any questions, I'll be happy to answer them. Thank you.
Thank you, Mr. Perez. Maybe you'll have to come and
You're
see us in person one of these days now that we're back in person.
Okay.
So you're okay with the urban forestry condition and the planning condition?
Yeah, I'm okay with it. We can protect those trees. We have lots of room.
No, it's UF1
I'll
is
get-
an
I'll-
application
I'll
to
get a-
injure a city tree, so you're okay with that? I guess.
Yeah, if you put, yeah, I'm okay with that.
Okay, let's see
I'm
if
okay.
anyone has any questions for you, or if someone's ready to weigh in with a motion.
If no one has any questions, I'm ready to weigh in. I believe this application meets the for tests under the Planning Act and move for approval subject to urban forestry condition number 1 and also community planning condition, which ties it to the site plan dated June 6th to 2023 as it relates to the front yard setback.
Okay, thank you, Ms. Alderson. Seconded for that motion. Mr. Taylor, all in favor? Application is unanimously approved. Thank you, Mr. Perez.
Mr. Chair, just going back to item 10, we've been notified that we did cut out for a moment, so people couldn't hear the decision. So for item 10, 46 Willingdon Boulevard, it was moved by Stan Komoric, seconded by Laura Alderson, and voted unanimously in favor to approve the application subject to a forestry condition.
As revised.
Yes.
Okay. Okay, the next application is item number 12, 4010 Bloor Street West. It's an application to grant a one-story west and rear additions. There are 2 variances. And we have on this application urban forestry looking for conditions 2 and 5 being a refusal. We have a forestry memo to deny variances 1 and 2 or UF2 if we don't agree to that. And we have supporting materials, photos, and transportation, I believe, is okay. The speaker is Enzo Lacasano, the only speaker appearing for the applicant.
Good afternoon, committee members, Mr. Speaker. It's Enzo Lacasano from RHDWG. I will be representing this file today.
Okay. Quite straightforward. I'd like to...
Yeah, again, we didn't get any comments from planning. Transportation is okay with it. We did have discussions with, because we put in an early application to forestry. Their view of these or this one tree, which we also got the neighbor's approval for as well in writing, which we submitted to the committee. We submitted it late to the committee. Was that there's no vehicle for them to not to decline the removal of this tree because in their view it's a healthy tree. Now we did submit a report to forestry with regards to as you know, Norway maples are considered an invasive tree, which is actually not native to Canada. It was actually in Europe and Asia. But after World War II, this thing was planted, but it was really meant to be a street tree in the urban setting because it is very resistant to insects, low maintenance, and so on. But the issue that planning has, and I can quote an email from forestry, is that they have no mechanism in the bylaws to account for the different tree species, including invasive species. So they basically left it to the Committee of Adjustment to approve this application with obviously the conditions of forestry, and we will have to deal with forestry separately. The biggest issue here is that the tree that's in question, the boundary tree, because it is invasive tree, it doesn't allow other trees to flourish. And if you look at the site plan, the neighbors had already planted an additional 5 trees, which seem to be stagnant. And the reason is because of this Norway maple. So again, the variances are very minor in nature. This is very much in keeping, this proposal very much in keeping with the neighborhood. It meets all the tests. It's really now just dealing with this tree and forestry, and I leave it up to Committee of Adjustment to for an approval on this application with the conditions of forestry.
Yeah, with UF2 being the permission to injure a privately, and we're talking about this privately owned Norway maple, 40.5 centimeters in the forestry memo. And that's basically
Correct, and it's the boundary tree that they're
Yes.
referring to. I think it's tree number 3.
Yes.
Because the other one they seem not to have a problem with,
Yeah.
which is also a Norway maple, which is directly behind the addition. But the boundary tree they seem to have an issue with.
Okay. Members, any questions for Mr. Lacasano, or someone ready for a motion?
Yeah, Mr. Chair, I'm satisfied that the variances requested meet the 4 tests under the Planning Act, and I move approval, subject to urban forestry condition 2.
Thank you, Mr. Taylor. Seconder for that, Mr. Kumarik. Thank you. All in favor? You have unanimous approval, Mr. Lacasano. We'll see you again. Come back and see us in person again. Okay. Next application, 13 and 14 have been deferred, so we can jump over to item number 15, which is 77 FLETCHERDON Crescent. And this is an application to construct a new attached garage located at the rear and west side of the existing dwelling. There are 3 variances. We have arborist report. Planning has conditions of approval regarding the length and the roof eaves and encroachments variances, and urban forestry condition number 2. And the speaker on this application is Marco Vieira, and looks like we have a speaker from 8 Maxine Road. Looks like we have that person in person. It said you're going to be virtual on video, but glad you came out. So we'll hear from you after we've heard from Mr. Vieira. Welcome, Marco. Welcome back.
Good
You're here this
afternoon,
morning.
Mr. Chair and members of the committee. Marco Vieira at 257 Dunraven Drive.
Okay.
And the application before you is to construct a new attached garage, as you've said, to the rear west side of the existing 1-story detached dwelling. We have 3 variances. The proposed side yard setback of 0.5, which is very similar to the property to the west side. That was done so that we don't push the garage into the rear yard and maintain most of the rear yard as soft landscaping. Variance number 2 has to do with the length. Because we are partially attaching it to the house, we're asking for a relief of 1.2 meters. Garage is also 1-story in height. This was done to respect the existing window openings and door openings along the side, and utilizing the existing driveway that now exists. And the third variance has to do with the roof or eave encroachment, because we do not comply with the side yard setbacks. So therefore, there's an encroachment of the eaves into the required side yard. There's no physical encroachment into the property line. And our proposal is very much in keeping to the property to the west. And I believe that it does not negatively impact the adjacent neighbors, and that our application does meet the 4 tests.
Okay, thank you, Mr. Vieira. Any questions for Mr. Vieira before we hear from the neighbor? Okay, so this next speaker is Barbara Martins, appearing in person at 8 Maxine Road. And if perhaps you can advise us where 8 Maxine Road is in relation to the property. I don't see it on our location map. It must be further out. Or unless you're appearing for someone else, and you live at 8 Maxine and you're appearing for someone else.
I used to live at 82 FLETCHERDON Crescent. My mom currently lives there.
Okay, so you're appearing as on behalf of your mother at 82.
Yes.
Okay. Across the street.
Yes. Excuse me for my ignorance. I don't understand what minor variances are. When I look at the first variance, number 1 and number 3, when I calculate it, those are over a 50% difference. So I don't know what constitutes a minor variance. My specific, I asked that this application be denied due to that they haven't asked for, applied for an application to the urban forestry for the destruction of the trees. In the designs, the measurements aren't shown, and the trees are very substantial. They're probably close to 70-year-old trees. Possibly could they adjust their designs to not include a 2-car garage, whereas a 1-car garage, most of the properties, they only have 1-car garages, as committees have refused to allow some of the property owners to put 2-car garages as they don't fit in. And I understand there's the arborists, the city, the urban forestries have requested that this be deferred to see the impact on the trees, and I also asked that.
Do you have a request from urban forestry for a deferral on this one?
Yep, it's in there.
Because, just to let you know, ma'am, how it works before we hear from Mr. Vieira. We're the Committee of Adjustment, and we can only deal with variances. So let's say it's not a variance to have a 2-car garage. We can't deny it. We can only deal with the 3 items listed there, being the setback from the west line, the length, and the eve encroachment. So we only deal with what's outside of the bylaw. We don't redesign homes or comment on.
And does that go by percentage of, like?
Well, it's not a variance to have a 2-car garage if they can fit it within the existing.
Yeah, okay.
They're not going over in terms of height or size or anything else that if you've been here this morning hearing about some of the other variances and some other applications. So we only comment on what is outside.
Okay, so variance number 1 and 3, if you're asking for more than a 50% from what's stated as acceptable, is that?
Yeah, it doesn't go by a numerical value. It's sort of what's in keeping with the neighborhood, what the prevailing build form is and stuff like that.
And he referenced the house next to it, the west building. That house, had I been given one of them when they extended I also would have objected to that one, because there's only.
We're only here dealing with this application, so.
Okay, but he referenced he referenced the other house that it's keeping in that one.
In the character of the neighborhood.
Yes, whereas that one is an exception. All the other houses are basically 1-car garages.
Okay. Okay, so we'll go back to, I guess, Mr. Vieira to respond to what you've had to say.
One moment, Mr. Chair, while I get that set up.
In terms of the tree, I guess the tree is in the rear. Your mother's in the front, so that's
Actually,
rear yard tree they're talking about. But urban forestry is, where is it here? Urban forestry is asking for a condition 2, which means permission to injure or remove a private tree. So that's what they're.
According to their pictures, they're going to remove 3 plus 4, 5 trees. Basically, all the trees will be removed, and this property owner has already damaged another mature tree without city approval, so I know they have no respect for the.
I see they have attached an arborist report from Davy, which would have been provided to the urban forestry department at the city, and they seem to be satisfied. They're not asking, like in the last application, we heard for a refusal. If you heard the last application, urban forestry was looking for a refusal, but it wasn't refused. Okay. So let's go back to Mr. Vieira then for his rebuttal, and then the committee will make a decision.
Go ahead, Marco.
Mr. Chair. Just in response to clarify with regards to the application to forestry, we have made application to forestry. We've also have paid for the application fee. That's going back to June 12th. Normally, forestry doesn't provide a decision or process the application until we go through the Committee of Adjustments process. That's why we don't have an indication. We did prepare the arborist report. There was a previous infraction related to an existing tree that was in the rear that has been dealt with, and my client has taken care of that issue in the past. With regards to the proposal, I actually think it's very minor and not impactful to the adjacent properties. It's in the rear of the house. The streetscape is maintained. There is a slight slope on the existing lot, so the garage will actually appear to be lower than what it actually is. It doesn't impact the adjacent properties, doesn't negatively create massing or making this garage appear to be higher than the house. So I don't think that the proposal provides a negative impact to the adjacent properties, and I believe that the variances that we are seeking are minor.
Okay, thank you, Mr. Vieira. Any questions, Mr. Clerk?
Yeah, Mr. Vieira, the current situation, is there a carport?
Through you, Mr. Chair, there is a large carport.
Is the carport to
onto
be
the
maintained
existing
or
side.
removed?
No, part of that carport is going to be removed.
So you're going to change the roof line of the entire house then as well?
Right. The existing house stays the same. The portion of the roof on the side, it's going to be reduced, I guess, because it's going to be cut back as the other portion of the garage then attaches to the back of the house.
No, understood. So you're actually reducing some visual massing from the street in essence by removing the roof over the carport.
Correct.
Okay, thank you.
Okay. Any other questions or comments, or is someone ready to make a motion?
Sorry, one other question. The owner of the, I would say, sister property, the one that has the other double car garage, number 75, is it? Is there any comments from them?
Through you, Mr. Chair, no, we are not aware of any concerns from the adjacent neighbor.
Nor do you have an
I
approval,
believe-
like a support letter or anything from them either?
I just don't know. I don't have an actual letter. I just know that they have spoken, but I am not aware of any concerns with regards to our proposal.
Okay, because that's the side lot setback is most affected in that way on that property. So I just wanted to.
Right.
Okay, thank you.
And we're maintaining it, and that's why we're kind of mirroring what they've got in terms of the side yard setback, so that we're not infringing anything closer to that existing side and the existing condition to the west.
Okay.
Okay, and Mr. Vieira, you're fine with the proposed community planning conditions of approval?
Through you, Mr. Chair, we've reviewed them and we're fine.
Okay. Okay. Someone's ready for a motion?
Yeah, I'm good to go with a motion. I believe the application meets the 4 tests and would like to move approval subject to forestry condition 2, subject to planning condition with regards to tying it to the site plan of June 7th as it relates to building length and roof encroachment.
Okay, thank you, Mr. Kamark. Seconder for that.
I'll second that.
Thank you, Ms. Alderson. All in favor? You have unanimous approval. Okay, thank you, the neighbor, for coming in, and thank you, Mr. Vieira. And we can move on to the next application, which is item number 16, 8 Edenbridge Drive. It's an application to construct a new detached dwelling with an attached garage with 8 variances. And we have before us a little bit of confusion on urban forestry. We had a deferral request, then we had a separate memo from TPPR, which is Tree Protection and Plan Review, new name. A memo asking for a deferral or urban forestry 2. And then we look in our consolidated, we're looking for urban forestry 4. And then the additional materials for urban forestry 1. So we're going to need to get some clarity on what's happening with the trees. And it looks like other than the trees, other than the forest and the trees, it doesn't look like we have comments. We have an arborist report and TRCA comments, again, advising they have no objection and just that there is a review fee that's going to be applicable post-approval. Okay, so the speaker on this, we only have the one, is Jim Kotsopoulos. So, Mr. Kotsopoulos, if we can let us know what's going on with urban forestry, and seems to be all over the place. Other than that, it looks like the application.
Good afternoon.
Yep.
Good afternoon, Mr. Chair, members of the committee. Thank you. And yes, Mr. Chair, you did raise the most prominent issue, and we were made aware of the urban forestry comments about a week ago. So I reached out to the arborist and who prepared a very detailed report that was posted on the Application Information Center since early June. And Mr. Chair, based on the analysis and the staff report from urban forestry, our arborist did confirm that in the report clearly details that the 3 trees identified in the urban forestry review and recommendation are clearly slated to be retained and protected via extensive injury mitigating measures, is the exact quote, sir, in the arborist report. So we've identified that to urban forestry, and I'm not too sure if they reviewed the submitted plan or not, the report, Mr. Chair, but our report as submitted clearly identifies the 3 trees identified by urban forestry to be protected in accordance with city standards.
Okay, what about the rest of it seems community planning has not weighed in on this. There's 8 variances.
Mr. Chair, I reached out to them. I did not get anything back in terms of
Okay.
any comments.
Okay. Members, any questions for Mr. Kotsopoulos or someone ready for a motion? And again, so you're saying that the applicable request from urban forestry, to your best of your understanding, is what condition? With respect to, we see just on the beautiful property with some large trees in the front and probably others in the back.
That's correct, sir. This is a ravine lot, and we did our utmost, obviously, protect what needs to be protected, and including the 3 trees identified by urban forestry in their report.
Okay. Yep. Members, any questions or someone ready to weigh in?
I'll weigh in, Mr. Chair.
Okay.
I'm satisfied that the variances meet the 4 tests under the Planning Act. And to be safe, I would like to propose approval subject to both conditions that have been requested by urban forestry at different times. 1 and 2 pertaining to city-owned and private trees.
So just to clarify, 1 is from urban forestry, just regular trees all around the city. The other one is from ravine. So they have a concern about a ravine tree. So that's why there are 2 separate memos. 1 is from the ravine area, 1 is just urban forestry.
Okay, then.
So yes, both conditions are appropriate.
Okay.
Can I just add, just for clarification, there was no requirement for bird-friendly window treatments either, so that was a surprise to me because it was on a ravine. Anyway, there wasn't.
Yeah, the bird-friendly window treatment and the dark sky, night sky compliant light fixtures, exterior light fixtures.
There was nothing from planning on that, so I don't know if we can make.
Perhaps we can, what Mr. Kotsopoulos feels about that. Mr. Kotsopoulos, typically when we have ravine lots, as Member Alderson just pointed out, we have a request from community planning for the dynamic duo of night sky compliant light fixtures and bird-friendly window treatments.
Mr. Chair, if that pleases the committee, then I have no issues in terms of adding that as a review condition.
Okay.
It's just we don't have the wording for that. So
sure
you would
we
have to tell us specifically, and I don't know
I
who's
think
going
we
to sign
can
off.
pull it up from another application. It's pretty standard wording. I think it's bird-friendly window treatment and night sky, dark sky compliant outdoor exterior light fixtures.
The wording is on item number.
Okay, apparently we
item
do
21.
have,
Item
apparently we
21 has
do
the
have a planning report that was not included in your report, in your agenda, so.
Yeah, because if you want the wording, it's Member Palmer just noted that it's appended to the decision or the recommendation planning condition in item 21 this afternoon for the
So
wording.
it's not even posted.
So what does the planning report say?
Yeah.
That would be interesting to know.
That's,
We're going to pull it up and share it with you.
okay.
Sorry about that, everyone.
Sometimes I am on the ball.
Oops. A little too small. A little too small to read. Can you just read the quotes and what's the recommendation and the? Is there any conclusion in the first line?
Conditions? Can someone read out the conditions?
Yes, the following condition be imposed on the plans and drawings to be approved by the chief building official and executive director, Toronto Building, for issuance.
Okay, you don't have to word to
building.
read word for word. It's the standard condition we were talking about, correct? Those two.
Well, they're not standard, that's why we need the wording, we can't just make it up.
Yeah, so whatever is taken in this case from the planning report, now we don't have to come up and copy the one from item 21. We have the specific one being requested by community planning. What's the date of the memo? It's just, okay, June 30. Okay. So it's been around for a while, but just didn't make it into the package, so. Okay, so that's,
So did I do a friendly amendment for that?
I take it. It was your memo, your motion?
No, someone made a motion, but there was
Right, and then
nothing,
you
so I'll
mentioned that, and then we
motion,
found that.
so maybe-
Okay, so
Maybe-
John can just revise his
Can I
motion.
withdraw the first one?
Right.
And make a clean one?
Okay,
Yes, do that.
I move approval on grounds of being satisfied that the application meets the 4 tests under the Planning Act on condition, subject to urban forestry condition 1, tree protection and plan review condition 2, and the condition of the community planning department.
okay.
And I'll second that motion.
Okay, thank you. All in favor? Okay, unanimous. You have your approval. Thank you, Mr. Katsopoulos. Okay, our next application is item number 17. I assume that people in the room here are on item 18, which is the application we're going to do next, because that is an opposed application, and we have a note that both area neighbors are going to be appearing in person, so I assume that's you, and not on item 17. So item 17 is 1162 Kipling, and it's an application to enclose the existing front porch and construct a new front porch with 4 variances. And we have planning condition of approval regarding the length and front yard setback. Other than that, we don't have anything. And the speaker on this application is David Moscow.
Good afternoon, committee. It's Dave Moscow here, agent for the owners. I'm at 14 Augustus Terrace.
Okay, rather simple application. You're enclosing the front porch and constructing a new front porch in addition to that with 4 variances. I don't believe we need a fulsome application, presentation on this. Is there anything you'd like to advise the committee, or if not, I'll just see if the members.
Just all it is just a secondary airlock vestibule from the 4-lane Kipling Avenue because of traffic, noise, and dust.
Okay.
And that's really just a small purpose 61 square foot front addition, which imposes no hardship on any adjacent neighbors.
Okay, and you're okay with the proposed community planning condition?
Correct. Yes, we are.
Okay. Okay, members, any questions for the agent, or is someone ready for a motion?
I'm ready for a motion if no one has any questions. I believe this application meets the 4 tests under the Planning Act and move for approval subject to community planning condition that it be tied to the site plan and elevation drawings submitted on June 12th and as it relates to the building length and front yard setback.
Okay. Seconded for that, Mr. Palmer, thank you. All in favor? Okay, it's unanimous. You have your approval. Okay, so we'll move on to item number 18, 387 Prince Edward Drive North. It's an application for a new detached dwelling with an attached garage and a cabana in the rear yard. There are 6 variances. And
Mr. Chair, can we stop for a moment? We think we may be having a bit of a YouTube problem here.
okay,
Maybe just a 5-minute break then, in a sense.
okay. Sounds good.
Stand up. I'm gonna go outside just to get some sun, yeah.
Adam?
I'm going outside to
know,
get
warm
warmed
up.
up in the sun. I just stepped outside. When was the last time you saw her?
No, I haven't seen her.
Oh, you haven't seen her.
But she had a place that she would be operating. It's freezing. It's cold.
It does make you more susceptible. Like, so when you're chilled, it doesn't. It's not that the chill gives you the virus. It's just it makes you more susceptible.
Everyone in the room is cold. She
Yeah. Just like a lack of sleep.
All right, Mr. Chair, we're okay now, so we can start.
Okay, so I believe I was just introducing item number 18, a new detached dwelling with an attached garage and a cabana in the rear yard with 6 variances. We have a covering letter with comparables and regarding Committee of Adjustment approvals regarding length and depth, which seem to be the two big issues here. Planning is asking us to refuse variance 3 and 4 regarding the length and depth. The length is, we have an urban forestry memo asking for a deferral or urban forestry 1 and 2. We have support from 386 Prince Edward Drive North, and we have opposition from 385 and 389. Both parties are here in, the parties in present are 389 and 358. The objection letters are from 385 and 389. Okay. And in the additional materials, we have concern from 390 regarding a front yard tree. Okay. The speaker, so we'll start off with the speaker for the applicant is Anthony Gornick, and then we have the neighbors in person from 389 right next door, and the neighbor at 358 as well.
Mr. Chair, members, I'd like to bring to your attention that the one area neighbor is actually remote and will be, they have called in on the WebEx.
Okay, which one is that?
Nathan. 389.
Okay, so he's the one right next door. He is not here in person. He'll be on video.
Correct, and we can confirm with the people in the crowd, but I'm under the impression that
So I assume the people here, the 4 people, are just Christine Sandig at 358 and her supporters or speakers or lawyer or representative, no?
No, Mr. Chair, they are not.
You're just here observing or for the afternoon?
So I'd like to let you know that the area resident at 358 is not present on the call time.
Okay. And that said they were going to be in person, so. Okay, so we have Anthony Gornick. Mr. Gornick, just to let you know, there's one speaker after you, the next door neighbor at 389, and we have their letter. So let's get started.
Anthony, you're unmuted. Go ahead.
Hi, Anthony Gornick here as agent for 387 Prince Edward Drive North, and I reside at 405 the Kingsway in Toronto.
Okay.
We have been retained to design and construct a new home at this property, and after completion of the design drawings, we request 6 minor variances. We are aware of the submitted planning department staff report, the forestry report, and a few letters from the neighbors on Prince Edward Drive. The minor variances are as follows. The maximum permitted lot coverage is 33%, or 171.77 square meters, We propose to have a lot coverage of 190.80 square meters, or 36.7% the lot area. We respect and submit that this proposal to be minor as it relates to the recently redeveloped homes in the direct vicinity. The maximum permitted gross floor area is 260.25 square meters and up to a maximum floor space index of 0.5. We propose to have a GFA of 351.10 square meters, or 67% of the lot area. Respectfully, we submit this variance as we feel it minor, as this relates to the recently approved minor variances in the Kingsway, many of which we found to be exceeding 79% of the lot area. The permitted maximum building length is 17 meters and the building depth is 19 meters. We propose to have a building length of 19.15 meters and a depth of 19.51 meters. We feel these variances are appropriate in comparison to the neighboring homes. As an example, the property to the north with a driveway abutting our property has a detached garage structure which extends far beyond our proposal. Similarly, the neighboring property to the south was granted 19.66 meters as a variance for both length and depth, which numerically is greater than our request today. In the immediate surrounding Kingsway area, numerous past applications have received permission for dwelling length and depth variances. Most notably, minor variances obtained up to 21.25 meters for length and exceeding 23 meters for depth. The maximum permitted height of an exterior portion of side wall is 7 meters, and we propose the side wall height of 7.21 meters. And the final minor variance in our submission is related to the minimum allowable width for a pedestrian stair that encroaches into a required setback, which is 2 meters. We propose a rear-facing two-step landscape feature that's 4.47 meters in width. With all of the above, as noted in my submitted covering letter, we respectfully feel that our overall application to be appropriate as this relates to the general Kingsway area and also consistent with the recently redeveloped new homes constructed in the direct vicinity. I hope I have addressed the concerns of the planning department memo and the neighbors submitted covering letters. With regard to the forestry memo, the proposed rear yard cabana is along the south property line and will not impact the noted tree from this memo. As for the front yard tree, our proposed new home is further away from the front property line and as such also further away from this noted tree. With the driveway, we propose to locate the new driveway in the same location as the existing driveway and will not impact the front yard tree at all. An application was submitted to forestry on June 8th, and we've had initial correspondence with Daniel Chandler, who's one of the planners at forestry. And of course, as a standard provision, should there be a favorable decision today, we will obtain what we'll do. We'll make every effort to obtain our clearances with regards to trees. That's my submission.
Okay, thank you, Mr. Gornick. While you've been speaking, I've been looking at again which I reviewed last night, the planning memo. So it seems they say in the immediate context, there's only been one approved for length and depth, and it was below grade, and they talk the lack of previous minor variance approvals in the immediate context to surprise the building length and depth. And I note that the depth is you're only a half a meter over, and you're a little over 2 meters over on the length. Can you explain the difference between the length and the depth, and why community planning seems to be digging in their heels, not even allowing a half a meter variance, or specifically in the depth? You're 2 meters in the length, but can you explain to us why there's that 2 meter difference? I believe it's where the measurement starts between length and depth, but just add that to your presentation, or answer that question.
Yes. Yes, so the dwelling depth is actually calculated from the minimum front yard setback delineation. So when we look at the site plan, our proposed front yard setback is 10.65 meters, which actually is an increase from the current condition, which is at 10.01. From that minimum front yard setback line, the maximum proposed depth of the building is calculated. As far as length is actually taken from the design, and there is a differential in the way these two calculations are sort of, calculated. It is a bit confusing. The other sort of related variable is the minimum rear yard setback. The minimum rear yard setback for this site is 10.067 meters, and we're almost 2 meters further away from the minimum rear yard setback. So the massing of the home, in theory, we would be allowed to sort of extend it further into the rear garden based on the minimum rear yard setback calculation.
And the other thing is, am I correct in saying that the length is only with respect to a portion of the property? There's
yes. So we have,
as an alternative to community planning's request to refuse these variances, if it was tied to plans, assuming it was approved, that be something acceptable to your client to keep them honest about where the length and depth exceeds. And having answered that, then we'll hear from the one neighbor that we're going to hear from, the next door neighbor, and I believe you've already read their letter. So
yes, I have.
Okay. So let's hear then from. Does anyone have any questions for Mr. Gornick before we hear from the neighbor? And we do only have the one neighbor to hear from, and we'll get that neighbor's letter on the board while we do that. Okay. So the neighbor is Nathan Slichter at 389.
Nathan, please let city staff be responsible for muting and unmuting. Go ahead.
Perfect. Thank you. Can you hear me?
Yes, we can. Welcome, sir.
Perfect. Thank you. This is Nathan Slichter. I reside at 389 Prince Edward Drive North, which is the property immediately to the north.
So that's the side, just supposed to say, that's the side where we have the length and depth issue, which is not across the whole lot, but you're the one impacted by that because it's on your side, correct?
I think it's across the whole back. Both are impacted to me, but
okay. But there's more of a jut out on your side.
Yes, there's a definite jut out on my side.
I'd say you're the most directly affected. Congratulations. Anyway, let's hear your concerns, and we'll get your letter up on the board while you're making your presentation.
Thank you very much.
Okay.
So this two-story above ground proposal is 20% deeper than any of the other houses on the street, including the two brand new builds, which are 385, who've also submitted a letter of opposition, as well as 379, which is a few houses away. And when I look out of my backyard and I see how far those two houses protrude into the backyard, this proposal would be 10 feet further into the backyard than either of these two brand new builds, which is quite extreme. As noted by the builder, we do have a detached garage in the backyard. I believe it to have been there since 1930, when my home was originally constructed. This is in keeping with normal houses in the area. This new build or proposed house would actually go halfway through that back garage that I have. So this would be a large difference to our outdoor space, both in terms of what we can currently view, as well as our privacy, as there will be many windows looking directly into our side backyard. The other house that was just previously built, 385, although it does have that main wall, exception that they were granted, it's below ground or below grade, and so it doesn't impact what any of the neighbors would see. So the house doesn't appear as large as the approved footprint that they currently have. So I would ask that you continue to uphold the that the COA uphold this bylaw for length and depth, as this to me is not a minor variance. To me, it's 10 feet deeper into the backyard, which I feel is quite excessive.
Thank you, Mr. Schlichter. I'm just looking at your letter and your chart that you've given and of the statistics. So is your house not your house 19.66? Isn't that longer than what they're asking at 19.15? House length.
No.
House depth. Am I looking at your? It shows your house is 19.66, includes the excavated black porch, and the house length is 19.66. That's on your letter.
No, sorry. I'm referring to my neighbor's letter for 385. My house is not.
Oh, sorry. Yeah, I'm looking at the Trenholmes letter. I'm sorry. But the Trenholmes letter talks about your house being longer than the proposed. Did you see? Can we get the trend? I was looking at the wrong letter, but that letter is perhaps relevant. You mentioned the chart, and that's why I looked at it. So they have their own chart. Is there an error in their chart?
I couldn't say if there's an error in their chart. I did reference it because they do have those statistics available to us.
Right, but I'm looking at their letter. I'm not. Then I'll look at your chart, but I'm looking at their chart, and it shows 385 has a depth of 19.66, including the excavated back porch, and the house length is 19.66. And you're here objecting to their 19.15. So that's why I'm a little confused. Sorry.
Sorry. Now I understand your question.
Yeah.
So I think this is the point of the above ground versus the sort of below ground basement. So that footprint that they have is that 19.66, but it's all underground. So their house is actually only, I believe it's 16 point something above ground, which is a lot less than it's less than the 17 that they're allowed to be, I guess, above ground. And whereas this one would actually be the 19 meters deep.
Okay. Again, they're not talking about their house. The Trenholmes or whatever their name is, they're talking about Trenholmes are talking about your house on their chart. 385. Are you saying to me that your house is below ground, or you have an excavated back porch? And
no.
Okay, so just take a look at their letter. Can we get their letter up on the board?
Sorry, yeah.
And I think your letter's, there's your chart. But their chart says that your house, you're deeper or longer than they are, than the proposed proposal before us.
Would this be considered an iceberg house?
Yeah, can we please get that up on the board? Not Mr. Schlichter's, but Mr. Trenholme's letter. The second letter in their bookmark. That's the first one, second letter in the bookmark. It's dated.
That's my letter.
Yeah, that's his letter. I'm looking about the other letter, dated. There's no date on it actually, but it's from the neighbors next door, the John and Julian Trenholme, at 385. Oh, they do talk about who's at 385. Oh, you're at 389. Okay, they're talking about their home, not yours. I'm sorry.
That's okay.
They're indicating their own house is longer than what's proposed. So, was anyone opposed to what they did?
Yes, we were all opposed to what we did.
Okay.
The committee of adjustments, cited that they withdrew their application, and then they came back with a much smaller, above grade sort of footprint that everyone was amenable to.
Okay. Okay, I don't understand because they're objecting, and they're objecting to not just that, but other things as well. The depth and length, also the GFA, but they point out that their own home is actually deeper and longer than the proposed application before us. That's just what I don't understand. So perhaps I was looking to you for some explanation of that. First, I thought they were talking about your house. They're talking about their own house.
That's okay. I think they're talking about their own house, and I think the explanation is that the footprint that they were granted is all below grade. So the below grade was in excess of the bylaw, but what they built above ground was within the bylaw. And they're objecting because this proposed house would be, it's about 10 feet further or back into the backyard than their above grade house is currently.
You're correct. I just saw it said our newly built house at 385 approved in 2020 is above grade 16 meters, but on their chart they put the 19. That's what confused me. Okay, so let's. Does anyone else have any questions for Mr. Slichter? If not, we'll go back to Mr. Gornick for his rebuttal because the other neighbor is not here.
Mr. Chair, we can clarify that actually. That other neighbor that was listed is actually for the afternoon session.
Oh, I see. Okay. So they weren't ever intending to be. It's not like they dropped off the call because
That is correct, and we'll update the records.
They weren't ever supposed to be appearing.
Correct.
Okay. Okay, so let's go back to Mr. Gornick for your rebuttal to the issues raised by the two neighbor letters and the presentation by Mr. Slichter.
Yes, we did have a phone chat with this neighbor to the north at number 389, and I sort of did a full explanation of our application as all the minor variances relate to his property. He currently lives in an original home where I guess the design standards and parameters at that time are a little different than what's happening today. So when you look at the site plan and the outline of his home at 389, I mean, it's fairly smallish, let's call it, in relation to what we're proposing to his south, and also as the recent home at 385 relates to his home. So, I mean, he currently has a fairly original home, but there is a garage massing that does project into the rear yard, which I think will kind of camouflage or mitigate some of the impact of our proposed design on his enjoyment of his rear garden. So as for the neighbor to the south, who recently redeveloped his home, I mean, he does have a variance that's granted at 19.66 meters, both for length and depth. One day he could easily, propose an addition that would go over top that. And, granted, he might have to come back to the Committee of Adjustments to get that. But I think because he has the existing foundations there, this would be a fairly easy sort of rebuild and extension if he decided to do that one day. So I feel that our proposal is in keeping with the area. I mean, I did submit a chart that illustrates some of the depth variances that have been granted in the Kingsway. Many of them are over 20 meters, up to 23 meters. As far as length, also up to 21 and a half meters for length. So we feel our application to be fairly consistent with the area. We find, I think our design is actually quite nice. It's, a fresher take on a Georgian home, very symmetrical, and in keeping with the architectural elements in the Kingsway, primarily Georgian homes or English Tudors. So that's my submission today.
Okay, thank you. Okay, members, any follow-up questions for Mr. Gornick or Mr. Slichter, or is someone ready for a motion?
Just a comment on the neighbor who made comments. They didn't really explain how the additional 2 meters of length was impacting on them. And in fact, when you look at it, it's all behind their garage. So I think it's got virtually no impact on them at all. So I'm looking at this application versus an earlier one that we had today, and they're not looking for any variances from front yard or rear yard or side yard. It's more the size of the dwelling they're looking for and the length. So
no height.
I'll be looking at probably supporting this, but would.
So you'd like to make that into a motion, or is
Well,
anyone
I'd
else?
like to
would
hear
to
from
make
anyone
comment?
else who wants to
Yeah.
comment.
Anyone else like to comment? No? Okay, so.
Okay, I'm going to move for approval. The variances requested are minor in nature and meet the four tests in the Planning Act. I'm going to make the length and depth variances tied to the site plan. So they're limited to where they are. And that's subject to urban forestry condition number 2.
Okay, thank you, Mr. Palmer, for that motion. Seconder for that motion. Mr. Taylor, thank you. All in favor? Unanimous? Unanimous approval. Okay, you have your approval. Mr. Gornick, thank you, Mr. Slichter, for your involvement as well. And we can move on to our last application of the morning session, item number 19, 6 Ridgedale Court. It's an application for a one-story front addition and a one-story rear addition above the existing dwelling. We have one variance, the FSI, 0.45 to 0.56. Supporting material, we have existing and proposed elevations and photos. And planning is asking us to modify the FSI approval to no more than 0.5 from they don't want 0.56. And they provided a memo. And urban forestry is looking for a refusal, or all absent that, urban forestry condition number 2, permission to injure a privately owned tree. Mr. Eagleman is the agent. Welcome back.
Yes, good afternoon now, Mr. Chair and committee members. It is, I didn't get a chance to say this last time, but it is good to see everyone in person now. David Eagleman, Design Plan Services, 900 the East Mall, Suite 300. I'm a senior planner here on behalf of the owners. Considering the comments made from planning staff, Mr. Chair, I take the committee would like a brief presentation. Yes, so
why are they saying only 0.5? I guess.
Yeah, so
it's 0.56, which is not, another halfway over. Where is the impact on that? Are they worried about precedent?
Yes, through you, Mr. Chair, I think what planning staff are tending to focus on is the fact that this specific street, and there have been approvals in the broader neighborhood, but this specific street has remained fairly stagnant, at least in terms of the approvals that can be obtained from the city, which are only from the last 10 to 15 years. There very well may be dwellings that are constructed on the street that are at a similar FSI to what is being proposed through this application, but have just not been captured within the research request that can be obtained by both myself and I believe city staff as well. There have been other approvals in the neighborhood. I will go through those shortly, but when I discussed this with staff, their options were this: either remove the front portion. This is just an addition above the existing dwelling. There's no expansion to the existing footprint. It is essentially an extension of the second floor at the rear, and then a small extension at the front above the existing garage. And when I discussed this with planning staff, their options, in order for them to be satisfied, were either bring the FSI to 0.5 times the lot area or eliminate the front addition. And eliminating the front addition would result in an FSI reduction of 1%. And they do acknowledge that those discussions were had within their staff report. So obviously, if we were to make any reductions, it would not be bring it to 0.5, it would be eliminating the front addition to bring it 1% lower. And while I acknowledge this recommendation or revision is minor, it also eliminates usable floor space within the addition for no apparent, or it would have essentially a negligible impact on the overall massing of the dwelling if we were to take off that front addition. So it is my opinion that the proposed FSI is in keeping with the existing character. There is very little change to the existing dwelling, no expansion to the existing footprint. There have been other approvals in the broader neighborhood. Just to go through a few, 34 Warrender approved at 0.55 times the lot area. 4 Tetton Hall Road approved at 0.53. 35 Orkney Crescent approved at 0.54, and 30 Farningham Crescent approved at 0.51. And lastly, I do note that forestry is recommending refusal as well. This is in relation to an existing tree that is directly adjacent to the existing rear covered porch. We are proposing to replace that rear covered porch. However, there's no variances related to that. It's not, the covered porch is not included in the FSI. Although I'm not an arborist, I don't see how the proposed FSI variance, which is the one and only variance being requested, relates to the proposed tree removal. And to conclude, Mr. Chair, I believe this application meets the 4 tests under Section 45(1) of the Planning Act. It's a very minor addition, 1 single variance, and those are my submissions.
Yeah, I think very key what you said, 1 single variance. There's no other variances, side yards. They're 1-story additions to improve the situation for the family of the owners of the property. So does anyone else have any comments, or is someone ready for a motion?
I'd like to ask a question first. Presumably, hopefully you've done the math on this. What's the difference between 0.56 and 0.50 in square meter terms?
I would have to do the math on that, Mr. Taylor. I don't have that ready with me.
It's about halfway between, if you look at the square footage of 282.21 and 351, so it's about halfway, I'd say, between 4.5 and it would be to 5.1.
So
it would be halfway. So you got 51 plus 18, not too much. About 70 square.
So it'd be like 320 square meters as opposed to 351.
Yeah, I'd say it's 35 square meters.
Roughly 35?
Well, it'd be 70 was because it's 282, 18 plus 51. 68? 314 square feet. Oh, we like
I'm pleased with that.
do that for square feet.
The question, through you, Mr. Chair, the question is the difference between the proposed FSI and the permitted FSI in terms of square meters.
No, I think he wants to know the difference between what community planning at 0.5 and what you want at 0.56.
Yeah, you want to build 351.3. What does the city want you to build?
Well,
313 sounds like the answer is.
I will accept that if Mr. Palmer has done the math on that, but I will also note, as I noted in my presentation as well, that that was one of the options to satisfy them. The other option was to reduce it by 1%.
Again, you have no other variances. No height, no length, no depth.
No objection.
No objections from anyone?
Yes, and to that point, through you, Mr. Chair, we have both adjacent neighbors in support.
Yeah, it seems like rather arbitrary that what they're just drawing a line on the sand. Anyway, so anyone else have any more comments?
Yeah,
or,
my only comment on that, they haven't explained how that impacts on anyone, how this variance impacts. They've just picked an arbitrary number. So unless you explain the impact, I don't think there's any justification for reducing the variance.
Shall I make a motion?
Yes, sir.
I'm totally satisfied that this application meets the 4 tests under the Planning Act, and I move approval subject to urban forestry condition 2.
Okay, thank you, Mr. Taylor. Totally satisfied.
Totally satisfied.
Okay. Seconder for
I'm
that.
not sure I'm totally satisfied, but I will second that motion.
Okay. All in favor? Okay, it's unanimous. You have your approval. Thank you, Mr. Eagleman. I guess we're going to see you back here this afternoon as well.
Yes, sir.
We have 5 items this afternoon, including I think 3 or 4 consents. So we'll see you back here. Staff, what time do you want to come back? 2:15?
Yes, please.
Well, you don't have to do a sound check, so.
We're gonna try because we didn't this morning.
2:15 then, or
Yeah.
2?
2:15.
Okay. Correct. Okay, thank you.